Yes. When the entry amount is going to expire? No, if it is expired, so 2 days before it will be listed as to be mentioned or extension of entry amount.
I'd like to mention 2 matters. One new motion and one is
New motion?
one is for hearing.
New motion of what?
Motion of motion.
CRR?
This is a new motion, wherein we were directed to serve. And what has happened subsequently, all these respondents, orders were passed expired. We were added subsequently in this proceeding. The main answering appellant, before the appellant court, that we have served. Rest against the rest, all the respondents against the ex parte orders were passed.
What order? Maintenance?
No, my property has been, an injunction has been passed.
Like the civil division?
Criminal appeal, because some dispute between a matrimonial was going on, so they claimed that is my house. My house to be the matrimonial house, while none of them are residing in my house.
So what is the criminality here?
Criminal appeal court restrained me from using my property.
In which proceeding?
My lord, in a DV Act proceeding. And I am not a defendant in the DV Act. I am not a family member to the wife or husband. That we have challenged. A very perverse order has been passed. Court has considered. And
in the DB Act or 125?
DV Act.
So DB Act, whether the CRR will lie or appeal will lie? Under section 9.
Appeal was filed challenging the order in criminal appeal. We have come before this.
Lordship, may I be permitted to mention 2 matters? This is for extension of interim order.
When the interim order is going to expire?
Lordship, the interim order has expired on 4th of May, but the application has been preferred within time.
Extension of interim.
One is for the question, Lordship, it has been served and
Who is appearing for the other side? So whether you served? Revision is admitted.
Lordship.
MSCC appeal? No. MSCC appeal, this court can be only higher taking the matters which has been assigned. Then you have to mention before the court number 1 if it is given or I will take it.
I humbly beg for your lordships in mentioning for grant 1 of 2025 in connection with the CRR number 606 of 2025. My lord, it's an application for the condonation of delay of 443 days. So, my lord,
condonation of delay for preparing a revisional application.
For preparing the revisional application. My lord, I would humbly present before your lordship the order that was passed by your lordship's coordinate bench.
So now what you want? What you want?
The grant 2 was allowed, but the grant 1, your lordship's coordinate bench has given an order to be placed before the next available bench for further consideration.
Lordship, praying for inclusion in the list.
What is the matter?
Compensation of motor vehicle accident.
MSCC you mentioned before the court number 1. If they will transfer, then I will take. Because it is only which has been given to this court, the court is taking.
It's kindly, my lord, to mention a matter, my lord, for my lord, extension of interim orders, my lord. My lord, it was filed on 21st of April, my lord. That is, my lord, before, my lord, it expired, my lord. But it was there in the list of lordship's predecessor, my lord, but due to paucity of time could not be taken up, my lord. So if it could be listed, my lord. And I was also humbly praying.
When interim order is going to be expired?
It has already expired on 21st of April, but the application for extension was filed prior thereto, my lord, before expiry.
Where is your mentioning list?
My lord,
my learned friend is there, my lord. And but I was saying, my lord, if my lord, the matter would be listed for hearing, my lord.
Okay, let's let the matter.
Obliged, my lord, deeply obliged.
Item number 1.
My lord, in item number 1, I am appearing on behalf of the petitioner, my lord.
ये क्या है? फ्लैग कौन लगाया?
My lord, I'm appearing for the petitioner, my lord, in item number 1 and 2, my lord. My lord's order has been complied with, my lord.
You are not seeing anything. What you doing coming in the morning? Yes.
My lord's order has been complied with, my lord, in item number 1, my lord.
Order has been complied with. Where is the order?
My lord. My lord. Big apology, my lord.
Record an order. Learned counsel appearing for the virtual mode submit that. Though the petitioner has filed the contempt application on the allegation that the alleged contemners are not complied with the order passed by this court in WPA 1504 of 2022 dated 8 September 2022. Now, full stop. After filing of the present contempt application, the alleged contemners are complied with the order passed by this court. Full stop. In view of the submission made by the counsel for the petitioner, the contempt application 74 of 2022 disposed of.
Grateful, my lord.
2.
My lord, in item number 2 also, my lord's order has been complied with, my lord.
Same order. Disposed of.
Grateful, my lord. Grateful, my lord. May take your lordship.
3.
Grateful, my lord.
Yes. Three. Who is appearing? 3.
আমি কন্টেন্ট সব মিলিয়ে মিশিয়ে দিলাম
None appears on behalf of the petitioner.
একটা
No accommodation is sought for the interest of justice. Case adjourned. Let the matter appear tomorrow. Next. 4.
I'm paying for short pass. Short pass.
So I am for the appellant.
Let us start.
Yeah.
You take note. Yes.
Lord, yesterday probably your lordship has considered it to some extent.
No,
Lord,
I have not considered anything.
Lord, the only question, my lord, on which this appeal was
Where
admitted.
is the paper book?
Paper book photo.
এক মিনিট
Yes.
Admission or order to here also. This number.
ওখানেই আছে
Lord, would kindly take page 315. The substantial question of law on which this appeal was admitted.
315.
312, my lord. 312.
Yes.
So whether the first appellate court was justified in holding that the appellant number 1, having entered into a partnership agreement and having permitted a partnership firm to operate from the tenanted premises, has parted his possession and surrendered his right to occupancy as a monthly tenant and has sublet the premises.
Yes.
But the second question is to some extent connected with the first question, whether the purpose behind execution of the partnership deed was ostensible and having granted permission to the firm to operate from the tenanted premises, the tenant has sublet the premises. Similar, the trial court initially, Millard, dismissed the suit. The appellant is the tenant before your lordship. The suit was dismissed since all the grounds taken for eviction in the plaint.
So you are
was-
the defendant appellant.
I was the defendant. One of the defendant.
Okay.
The other defendant was someone who is one of the partners with whom I have entered into a partnership agreement. Now, all the grounds which was taken was found to be unsustainable. The suit was dismissed.
Correct.
The appellate court reversed the first appellate court's judgment only on the ground on the point of subletting, that it was an unauthorized subletting. But I will show your lordship, my lord, how the appellate court has somewhere gone wrong in addressing the question. Before that, I will take your lordship to the trial court's judgment first. I will come to the documents later after showing your lordship how it has been decided.
Yes.
And the basis of determination, I will come later. My lord, it starts from page 77. I would request your lordship to, for the time being, only Millard to consider the issue of subletting, since that is the
77 is the trial court order.
trial court's judgment.
Yes.
It starts from 77. Millard would take page 86, where the issue of subletting has been addressed.
Yes.
Issue number 6, whether the defendant number 1 has sublet the tenanted suit premises to defendant number 2.
Yes.
In the plaint, it has been categorically stated that the tenant defendant number 1, that is so and so, is guilty of subletting the tenanted suit property to defendant number 2, i.e. so and so, without the consent of the plaintiff's landlord. Therefore, according to the plaintiffs, defendant number 1 has violated the provisions of the West Bengal Premises Tenancy Act, and thus the defendants are liable to be evicted from the tenanted premises. Now, my lord, the learned counsel for the plaintiffs during his argument submitted that the defendant number 1 used the tenanted premises not for the purpose for which it was let out to him. He initially started a toy shop and later on started a partnership business in the name and style of so and so. Now let us see how far defendant number 1 has been able to prove his case. Defendant number 1 admitted the fact that partnership firm started on 20th June 2014. I ran a stationery business in the tenanted premises from the year 1981 to 1982 for about 8 to 9 months. And he further admitted the fact, saying that prior 40 years, I used to run a toy shop in the name and style of so and so in the suit premises. One question was put by the learned counsel on behalf of the plaintiffs to the defendant number 1, that in which year so and so was changed to so and so. He replied in the year 2014. DW1 in his cross-examination admitted that I am the sole tenant of the tenanted premises. Further, DW2 on his cross-examination deposed that I am not related to Rabindranath Ghosh. He is not my relative. He further admitted
Who is
that
the Rabindranath Ghosh?
Rabindranath Ghosh is the tenant.
Who is the tenant?
Tenant. Defendant number 1, the appellant before your lordship.
No, the DW2. Who is the DW2?
DW2 is Millard, this Tibakar, who is one of the partners with whom I have entered into the partnership. It was with 4 partners.
So, who is the defendant number 2?
Defendant number 2 is also Millard, one of the partners.
So, how many defendants are there?
Millard, only 2.
Only 2.
Yes, plaintiff Millard would take page 1 of the paper.
Rabindranath Ghosh was the original tenant.
Original tenant, the appellant before your lordship.
Correct.
Correct.
And Dipankar Shah is?
Millard,
Divakar Shah is?
he is one of the partners with whom he has entered into the partnership.
He is the one of the partners.
One of the partners.
Okay. So, he stated in which? So, the DW2 is the
DW2 is Divakar Shah.
Divakar Shah is the
Yes.
defendant number 2.
The defendant number 2 also DW number 2.
Correct.
Right.
So, defendant number 2 filed return statement.
Yes, Millard. Yes,
File
filed a
written
separate written statement.
Okay.
DW2 in his cross-examination deposed that I am not related to Rabindranath Ghosh. He is not my relative. He further admitted that I am not the direct tenant of the plaintiffs. Thus, the statements of DW shows that he has no relation with the plaintiffs of this suit. As such, he may be presumed to be a trespasser. Second page. Millard, will kindly turns over. The learned counsel for the plaintiff advanced his argument by submitting that the defendant number 1 kept the shop closed for a considerable period of time, and subsequently defendant number 1 in August 2014 illegally sublet the premises to defendant number 2 without the consent of the plaintiffs. Thereafter, Millard, the provisions have been quoted. Millard can skip over for the time being for the next 3 pages. Now, Millard, page 91, internal page 14.
Yes.
The DW1 admitted that he did not inform the landlords that he has changed the nature kind of business in the suit premises, and further stated that he did not inform the present plaintiffs about the partnership business.
Yes.
Now, Millard kindly takes the next paragraph. The next paragraph, the submissions, Millard, I'll just read it out for your lordship. The learned counsel for the defendants in reply submitted that the defendant number 2 is the partner of defendant number 1 in his business, and that the defendant number 1 has not sublet the tenanted premises to defendant number 2. On perusing exhibit H, that is, Millard, the partnership deed, it appears that the deed of partnership regarding a business in the name and style so and so was made between the defendant number 1, so and so, Sri Divakar Saha, that is defendant number 2, and Millard would find the other names who are the partners.
How many partners are there in?
There are 5.
Okay.
Millard would find all the 5 names over here.
Okay.
The learned counsel for the plaintiffs in his argument submitted that the defendant number 1 has admitted the partnership deed. So that is not under dispute. In lieu, it can be presumed that the defendant number 2 is a trespasser. It has been admitted by defendant number 2 in his cross-examination that he is not related to the defendant number 1 and he is not the direct tenant to the plaintiffs, which implies that the defendant number 2 is not connected with the plaintiffs in the relationship of landlord and tenant, which the defendant number 1 and the plaintiffs enjoy. Thus, absence of blood relationship between the defendant number 1 and defendant number 2 does give this court an impression that the defendant number 2 was not related with the suit property when the defendant number 1 was originally inducted as a tenant. There appears to be no legal status of tenant conferred upon the defendant number 2 in respect of the suit property, as no prior permission from the plaintiffs were sought when he and the defendant number 2 opened a joint partnership firm. But in the case in hand, the right of occupancy as a monthly tenant in respect of the premises remained with the tenant and did not form part of the assets of the partnership firm. There could not be said to be any subletting. This is the findings of the court.
But in case in hand, right of occupancy is monthly tenant in respect of the premises
remained with the tenant and did not form part of the assets of the partnership firm.
Yes.
There could not be said to be any subletting. The next paragraph is important, Millard. Thus, in the case of subletting, the onus lying on the landlord would stand discharged by adducing prima facie proof of the fact that the alleged subtenant was in exclusive possession of the premises, or, to borrow the language of section 105 of the Transfer of Property Act, was holding right to enjoy such property, as presumption of subletting may then be raised and would amount to proof unless rebutted. Now, Millard would find thereafter, Millard, several judgments have been quoted, and Millard, the test, whether it was actually a subletting or not, the court has, Millard, elucidated the 2 tests at page 16 in the middle portion. A plain reading of the provision, it is quoted from 2008-14 SCC. I'm carrying a copy of the judgment also if Millard desires to have a look. A plain reading of this provision would show that if a tenant has sublet or assigned or otherwise parted with the possession of the whole or any part of the premises without obtaining the consent in writing of the landlord, he would be liable to be evicted from the said premises. That is to say, the following ingredients must be satisfied before an order of eviction can be passed on the ground of subletting. 1, the tenant has sublet or assigned or parted with the possession of the whole or any part of the premises. 2nd, such subletting or assigning or parting with possession has been done without obtaining the consent in writing of the landlord. So, therefore, Millard, it is the settled that the burden of proving subletting is on the landlord. But if the landlord proves that the subtenant is in exclusive possession of the suit premises, then the onus is shifted to the tenant to prove that it was not a case of subletting. Then, Millard, several judgments were quoted, and at page 17, Millard would find the final observation of the court. Thus, based on the above aforesaid discussion and observation made by this court, it is held that the defendant number 1 has not sublet the suit premises to the defendant number 2, and that the defendant number 1 is not guilty of subletting the suit property illegally in favor of defendant number 2. Thus, this issue is decided in negative against the plaintiffs. Now, while reversing this finding, how, Millard, the appellate court has dealt with it? Milord, kindly takes the appellate court's judgment. Which starts, Milord, at page 132. Milord would straight away come at page 140. Paragraph 23 is the appellate court's observation on this.
Page 140,
In page 140, internal page 9 of the appellate judgment.
140.
140.
Yes.
In the present suit, what appears is that the defendant respondent number 1 has filed a partnership deed at the time of trial, and the same has been marked as Exhibit H. On perusal of the said partnership deed, it appears that the terms and conditions of the partnership was such that the defendant number 1, respondent number 1, was required to provide the suit premises against the involvement of capital of the said business as an outlet point or showroom of the said business. This tends to show that the possession of the entire suit premises had to be parted with by the defendant number 1 for the purpose of running such business. However, the defendant number 1, respondent number 1 has failed to establish by adducing convincing evidence as to whether the partnership deed has been acted upon or not. This is where, Milord, the appellate court is traversing into a domain which was not a case made out, either in the plaint or in the written statement or within the findings of the trial court. Whether the partnership deed was acted upon or not was not an issue in the suit. The defendant number 1 has admitted.
So if the partnership deed is not the issue, so how you can say that you are in occupation of the premises as a partnership in terms of the partnership deed? What you're making is submission.
Yes.
If you're telling that that was not a issue with regard to the partnership before the trial court, and appellate court, the first appellate court has come to this finding.
Yes.
So, but your case since beginning is that you have since 86 till 2014, only 2 years you run the business. Thereafter, you closed the business, and 2014 you entered into a partnership deed, and the defendant number 2 being one of the partner, you allowed to continue the business. Earlier it was a toy shop, now it has been garment shop.
Yes.
Correct.
Yes.
So
Right.
this is your total cases with regard to the partnership.
Correct. Milord, rather I'll just rephrase it, Milord. As per my written statement and my evidence, all the 5 partners, including me, jointly used to run the business in that premise. That was what was
But
pleaded.
where is the evidence?
Yeah, I will show. Exactly, that is what the evidence is. Milord, I'll show. Milord, I'll just
Okay, continue.
let us see, Milord,
Yeah.
how the appellate court has dealt with it.
Yes.
Acted
defendant number one does
the
not
defendant
pay-
number 1 has admitted at the time of his cross-examination that the so-called partnership firm has not been registered with the register of firms. Moreover, although both the defendants and respondents at the time of their cross-examination have stated that there is a trade license in the name of the partnership firm in question, however, no such trade license was brought in evidence on behalf of the defendants. The defendant number 1 has also failed to produce balance sheet, books of accounts, income tax file, or any other papers or documents relating to the business from which it can be inferred that the partnership deed produced by the defendant has actually been acted upon. The defendant number 1 failed to show anything from which it could be believed that he is actively associated with the business. Thus, I am of the view that the defendant number 1, respondent number 1 failed to establish that the partnership deed produced by him at the time of trial of this suit is a genuine one. So, Milord, a sham transaction, a color of sham transaction has been interpreted. Now, Milord, the next line. Therefore, what remains is that the defendant number 1, respondent number 1 has actually parted with the possession of the entire suit premises in respect of which is a tenant to the respondent number 2 and other third parties without the consent of the appellant's plaintiffs, and that the respondent number 2 and others are running their business over the suit premises under the name and style of AP Garments. Therefore, it seems that the alleged partnership deed has been brought into existence only to give an outward appearance of partnership, whereas in reality, a subtenancy has been created by the defendant number one, respondent number one in favor of the defendant number two, respondent number two, and others under the guise of partnership by parting with his exclusive possession over the entire suit premises. It is also clear from the deposition of the defendant number one that he did not take any permission from the landlord before parting with the suit premises. The defendant number respondent number one has not been able to adduce any evidence to prove the contrary, that he is in actual legal possession of the suit premises. Now, therefore, Miller, this is the observation on the basis of which the court ultimately reverses that finding of the trial court. Now, Miller kindly takes what case has been made out in the plate.
Yes.
Page 2 of the paper book, Miller. Para 5.
Yes. Yes.
That initially, defendant number one was inducted as a tenant long back. This defendant kept the shop closed for a considerable period of time, and subsequently defendant number one in August 14 illegally sublet the premises without the consent of the plaintiff to defendant number two so-and-so, grandson of so-and-so, the address. For such subletting of the premises to defendant number two or hand over the same to defendant number two who is running the business there illegally and has violated the provision of Premises Tenancy Act, for which the defendants are liable to be evicted from the tenanted premises. This is the only pleading in the plaint with regard to subletting. Now, Millard kindly turns over to my written statement. It starts at page 8. Millard would
D2.
Millard
defendant
P2, correct. P2, page 8. Para 9.
Yes.
That the statements made in para 5 of the plaint are partly true to the extent.
Para 9.
Para 9,
Yes.
at page 9. The statements made in para 5 of the plaint are partly true to the extent that the defendant number one, after being inducted as tenant, kept the shop closed for a considerable period of time. But it is not true that subsequently defendant number one in August 2014 illegally sublet the premises to the defendant number two so-and-so. The defendant number one did not sublet the tenanted premises to the defendant number two and hand over the same to defendant number two for running on business illegally. Due to financial crisis, the defendant number one had to close the shop of the tenanted premises for a considerable period, and thereafter, this defendant number one, after a long gap, started business of ready-made garments in the said premises along with defendant number two as being a partner of the defendant number one. The defendant number one did not violate the provisions of the Premises Tenancy Act, and as such, this defendant number one is not liable to be evicted from the suit premises. Now, considering this statement in the WS and the way their allegation of subletting had been controverted, it was the onus cast upon the plaintiff to bring on record the factum of subletting and that the exclusive possession has been delivered physically and in reality in favor of the defendant number two or anyone else for that matter. Now, let kindly seize their evidence, what they have said in the deposition. Well, at page 16, but there was only one PW who was adduced and examined.
Yes.
Affidavit of Chief Millard, I am not reading out. It is more or less, Millard, what has been stated in the plaint.
Yes.
Now, Millard takes his cross-examination.
Yes.
It starts at page 22. Millard, I will not read it out, Millard, in its entirety. Millard can just gloss through from page 22 whether there was one clear statement in the cross-examination from where Millard would come to a conclusion that in view of the controversy in the plaint and the WS, they have discharged their burden of even prima facie proving what they have stated. The first cross-examination, Millard, it was deferred. There is nothing substantial. Only, Millard, the relationships have been brought out. Millard would turn over to page 23.
Yes.
Millard, kindly gloss through the statements once. At page 24, Millard would find only one statement that has come in cross-examination. Not a fact, Rabindranath Ghosh has sublet the tenanted premises is false. Page 24, the third line.
Now, this is a cross,
Cross-examination.
correct?
Yes.
So which portion you're relying upon? Page 24, third line.
Third line
Not affect that Rabindranath Ghosh sublet the tenanted premises is false.
is false.
So it is your cross-examination.
It
to
is
the
my
PW1.
it is my cross-examination
To the PW1.
with the PW1.
Correct.
And Millard in the affidavit in chief, examination in chief,
Hmm.
Millard would find the same thing which was stated in the
Correct,
plaint have been more or less.
Correct,
Millard
no problem.
sublet. Now Millard comes to my cross-examination.
Yes.
At Millard page 29,
It is DW1.
DW1, who is Millard the different number one also.
Page 29.
Page 29 of the paper book.
Yes.
Millard would take from the third paragraph onwards, which is relevant for this appeal. Name of my business is so and so.
Page 29.
Page 29, Millard.
Hmm.
Third paragraph.
Yes, name of my business is AP Garments.
Yes. Apart from myself, Millard would find there are four names are the
part-
partners.
Correct.
It is a fact that our partnership firm is not registered under the Societies Act. It should be Partnership Act rather. Millard, let us ignore that for the timing. It is a fact that trade license is in the name of our firm. It is a fact that the word is illegible, the first
QR
word.
code record আছে কি?
কি বুক আছে সার্টিফিকেট কপি থেকে But I have the certificate copy, Millard, I'll just place. It's the documents. Deposition টা বের করো। এটা judgment.
কি পুরোটাই তো
এটা রবীন্দ্রনাথ না এটার আগে Well, it is textbook. It is
Textbook.
textbook.
Okay. Okay. Textbook.
Textbook.
Yes.
It should be tax returns, probably. It has been gone down as book. Partnership firm started on 20th June 2014. এটা for AP Garments is এটা কি
AP Garments, I used to run the stationery business.
Yes,
Tenanted
from the day of the partnership firm started, prior to AP Garments, I used to run stationery business. Only I used to run the stationery business. I ran the stationery business in the year 1981 to 1982 for about 8 to 9 months. What did you do in the tenanted premises? 82 to 2014, I kept the tenanted premises under lock and key. I am the sole tenant of the tenanted premises. Now, Millard, find the next questions is there is nothing to do with subletting. Millard can kindly skip over to my next part of the cross examination, which is at page 31. The first paragraph. I cannot remember as to whether any lawyer's notice was served upon me before filing of the suit. AP Garments is a partnership firm. The partners of the said firm are myself, so and so, so and so, so and so. Only I was tenant of Vijay Sarkar prior 40 years. Prior 40 years, I used to run a toy shop in the name and style Ghosh Traders in the suit premises. Now, my lord, the DW2 against whom, my lord, the allegation of delivering of exclusive possession is there in the play. DW2 at page 37. Cross-examination of DW2.
Yes. Page 37.
Page 37.
Yes.
Milord can take from the second paragraph. On 26/2014, one agreement was executed in between so and so, all the 5 names regarding business which has been attested and authenticated by so and so notary. Swapon Chakraborty is my father-in-law. Nilakshi Shah is my wife. Enakshi Chakraborty is daughter of Swapon Chakraborty. These are my signatures in all pages of the agreement. I know the signatures of so and so, so and so, so and so. These are the signatures of so and so, so and so, and so and so. All the signatures were marked exhibit. Now, my lord, the next part of the cross-examination, that is, my lord, very important. I am not related with Rabindranath Ghosh. He is not my relative. Sanjay Sarkar and Manju Sarkar has filed this case against us. It is correct that I did not enter into agreement with the plaintiffs of this case. I cannot say as to when agreement was made in between plaintiffs and Rabindranath Ghosh. I also cannot say as to any agreement at all was executed in between Rabindranath Ghosh and the plaintiffs. It is correct that I am not direct tenant of the plaintiffs. I did not inform plaintiffs about the execution of the deed of partnership in between myself, Rabindranath Ghosh, my wife, my father-in-law, sister-in-law. House of that landed notary advocate, that is, my lord, not relevant. Now, my lord, the third part of my cross-examination at page 39.
Yes.
The first part. I have business of garments which is run by the name so and so. AP Garments is running since June 2014. The room where AP Garments is running was earlier in a dilapidated condition. There were trees inside and the room was also locked. I do not know as to whether Rabindranath Ghosh used to stay at Panipat, Vizag, New Delhi for the purpose of his service. Swapon Chakraborty, Enakshi Chakraborty, Nilakshi Shah, Divakar Sir, Rabindranath Ghosh are running the AP Garments after executing partnership agreement. And Millard, there was another question put, whether any income tax file in the name of AP Garments, it was not filed. That is, Millard, cannot be denied. That is that's the position.
Yes.
So therefore, as Millard, according to me, subject to correction by your lordship, as rightly observed by the trial court, from the materials and the evidence which was available on record, there was nothing to conclusively show that the physical possession of the premises were exclusively handed over to a third party. On the contrary, Millard, the materials on record suggest that it was a genuine financial scarcity which prompted the plaintiff, the appellant before your lordship, the tenant, to enter into an arrangement to get some capital infused in a business and start a business using that premises.
Where is the partnership?
Yes, that is the next document which I would show your lordship. Last time. Millard, take Millard, page 380. 380.
381.
380, it starts from 381.
Yes.
But I'll just show Millard clause 2, 6 and 7, that is relevant for my case.
Yes.
Clause 2, Millard would find the principal place of business. That was, Millard, the scheduled premises of the suit at clause 2, page 385.
Yes. Open branches of retail outlet anywhere in the Union of India. The dealings of the owner shall be mainly sold the ready-made garments.
Yes. Accounting capital of the firm, that is, Millard, it is there.
Yes.
Clause 6, the share of the defendant number 1 was fixed at 10%.
Hmm.
And 7 is the most vital clause, where it records that all the partners are working partners and they will be entitled to draw salary for taking part in the conduct of the business of the firm as such rate and from such date as may be agreed upon and so on. Similarly, it was never a remuneration which was agreed or a rent which was agreed to be paid to the appellant before your lordship. It was always a salary or a remuneration in lieu of his contribution to the business of the firm as a working partner. And Millard has noted he has a background of business, maybe in a different business, but he is a businessman by profession. So this clause that he has been inducted as a working partner may not strike unusual to your lordship. Should not strike unusual to your lordship.
Oh. Next.
And so far as Millard, the partnership deed is concerned, Millard, I don't think the other clauses are of any assistance to us, Millard, at least at this stage, unless your lordship raises any query to me. Therefore, Millard, the conclusion of the appellate court, the crux of the findings of the appellate court, that this was in the nature of a sham transaction or is to create an ostensible partnership, only to, Millard, create a cloud to shield illegal subletting of possession, Millard, subject to correction by your lordship, may not be correct. And that's what precisely, Millard, the Honorable Supreme Court has also dealt with it, that it has to be examined whether it is ostensible or it is real. If it is ostensible, your case goes, yes, it is a case of subletting, you have no defense, you have to be liable to be evicted. But you have to examine whether this was ostensible and whether, Millard, or whether it is real.
For to prove that it is ostensible, there are 5 partners.
Correct.
We have not disclosed that there are 5 partners in the written statement. Have you disclosed in a written statement? No. It is not in your written statement. Yes, after entering into the partnership, the profit and loss has been maintained by your partners, and this is the document which shows that this is also included in your return or document. Yes, this is the part of the partnership business. Where is that?
Now, Millard, before coming to mind.
Now, let the court complete. To prove the partnership between the parties, first the parties has to prove, yes, you have invested this much amount and you have invested this much amount and you have invested this much amount. This is the first criteria.
Right.
Second, the yearly, because as per your clauses of the partnership, you have to maintain the proper books of account. The books of accounts, whether your business is going in the loss or profit. There's no. Third, if the whatever the business, it is a business, it is not only the defendant number 2, it is the 5. So where is the document you produce? Yes, the plaintiff, the defendant number 1 also getting the profit from the business which has been given to the defendant number 1 as a partnership.
Right. Millard, I bow down to the queries. Now, Millard, as a defendant in the suit, I am only supposed to controvert the case which has been made in the plate.
But subsequently,
in
which
the
the defense you have made out, that defense has to be proved by you.
Yes.
Because they have made out a case
Right,
of the
absolutely,
sublet.
absolutely
And
right.
it is admitted by you.
Yes.
You are not in the running by the defendant number 2, only
Correct.
the ready-made garment.
Correct.
So you have to prove your partnership. Yes, this is the partnership deed, and in terms of the partnership deed, in accordance with law, the business is running under the partnership, and I am also getting the profit from the business. So it is not only a sham deed, sham document. It is the document which is in existence and have acted upon.
Right. Now, Millard, kindly see, the plaintiff restricted themselves by only alleging that I have exclusively made over possession to the defendant number 2.
Correct.
The story of partnership, or that, Millard, there are other partners, or that, Millard, even after coming into knowledge of the fact that there has been a partnership agreement, there was no amendment carried out.
That's why I'm asking. First question I ask you. question of amendment will come when you have disclosed your defense in the written
Yes,
statement. Kindly
yes.
come to your written statement. Have you
Yes.
disclosed in your written statement?
Or
You are the
written
five
statement of
partners.
that,
Have you disclosed in your written statement? You are the five partners in the return.
I'll show Milord.
Kindly come to the written statement.
Yes, I'll show Milord.
Defendant number 2 has not filed any written statement. The written statement only filed by the defendant number 1.
Page 8.
Page 8 is a written statement of defendant number 1 only.
Deepak written
Whatever it may be.
Nothing is there. What has come from your lordship is perfectly correct, my lord, nothing is there.
হ্যাঁ দুজনের জন্য একটাই রিটেন স্টেটমেন্ট তো it was only stated that after a long gap started business of ready-made garments in the said suit premises along with defendant number 2 as being partner of the defendant number
Defendant
1.
number 2.
Right.
And defendant number 2 already is the party because they have made the
Right.
defendant number 2 as an illegal occupier on the allegation that you have sublet to the defendant number 2.
Correct. Correct.
The defendant number 1 filed the written statement stating that no, it is a partnership with the defendant number 2. Defendant number 2 is running the business.
Right.
You have changed your defense in the cross examination that you are the five partnership.
Right.
So whether
Right.
you are disclosing in the evidence whether the plaintiff will get the chance to
Even after the cross-examination and even after Milord, when I had myself came and produced and adduced Milord the partnership deed as a part of my evidence, there could have been an amendment carried out.
I don't think so.
There is no bar in law.
I don't think so.
Milord, because there
As
would
per
have
the amendment CPC,
Milord, there would
if
not
you disclose anything during the first of all, that evidence cannot be taken into consideration which is not in the pleading in the written statement.
Milord,
What the law
pleading
says, I understand.
the pleading as to partnership is there.
You have to, your defense is only with regard to the what the defense you are disclosing in the written statement.
That's right. That's
Correct.
right. That's right.
Then because
Milord, that allegation, Milord would
why?
also consider that the allegation against me was never that I had entered into a partnership. The allegation that I have exclusively handed over
Correct.
possession to someone.
Correct. That's because their case is simply two lines.
Two lines.
Two lines.
Two lines.
You defendant number 1 is the original tenant. One is the original tenant, sublet to the defendant number 2.
Correct.
Correct.
So that has been controverted by saying that no, it is
your
not a
defense-
case of
yes, that's
delivery of
why
possession. It is
you-
a case
you-
of partnership.
You are taking the shelter with regard to the partnership.
Yes.
With regard to the
Absolutely.
partnership, the
And
trial
Milord,
court,
it was
trial court.
it was also Milord, once the moment that statement came that it was a partnership, it was also Milord within the domain of the plaintiff to conduct a due diligence that what kind of partnership, whether it is a registered, it is notarized, that could have been ascertained. It is
Okay.
all notarized, registered, both are public documents.
Okay,
It could have been assessed.
Okay.
Now, Milord, kindly seize Milord. I will just Milord show just 2 or 3 Milord observations from the judgment of the Honorable Supreme Court.
Yes.
ওইটা দেখা তো আগে হেল্পার And Milord would also, Milord, kindly take note of this, Milord, that whether the partnership was ostensible or it was a
That's
merely,
what I'm- that's
merely
what I'm asking.
a real partnership,
That's
that
what I'm asking.
that
See,
issue was never framed.
not framed, but मैडम को बोलो जजमेंट निकाल के Yes. Yes, which paragraph?
Milord, para 8, Milord.
Para 8.
Para 8, Milord.
Constructed.
1987 PSCC 538.
Yes.
But para 8, 11 and 19.
Yes. 8, 11. 8, 11 and 19.
And 19.
Yes.
I'll just read para 19 Millard for my satisfaction.
Yes.
In the instant case, the basic question is whether, keeping in background the partnership deeds referred to herein above and the facts that came to light, was there partnership or not? Sharing of profits and contributing to losses were the only elements in a partnership. Existence of agency was essential, and whether there was a partnership or not is a mixed question of law and fact, depending upon varying circumstances in different cases. This view was reiterated by Chief Justice so-and-so in so-and-so and so-and-so observed that whether the relationship or partnership between two or more persons does or does not exist must depend on the real intention and contract of the parties and not merely on their expressed intention. He also referred to Section 4 of the Partnership Act about the principles of partnership, namely, there must be an agreement entered into by and all the persons concerned. The agreement must be to share the profits of the business. The business must be carried on by all or any of the persons concerned, acting by all. According to me, Millard, all these three conditions on the face of it has been prima facie proved and not rebutted by any evidence by the plaintiff. In the instant case judged by the aforesaid principles, it is possible to hold that there was a partnership of which the appellant was a partner. The Court of Small Causes considered these principles, evaluated the evidence, and held that there was in fact and in law a partnership. Such a view was not an impossible one nor a perverse one. If that was so, there was nothing that could be done about such a view within the ambit and scope of the power under Section 29(2) of the Rent Act. This was also a case of eviction sought to be defended on the ground of partnership. Now, Millard would see my reply to their notice of eviction, wherein Millard it was clearly Millard stated. Millard would take page 334 once.
334.
334.
Yes.
This was also exhibited. Millard would take from page 333 onwards.
Yes.
The last paragraph.
Yes.
My client started business in the tenanted premises for few years, but as the said premises was very old and not favorable for carrying on business, my client had to close his business, and due to such closure, he sustained heavy loss. But subsequently, by making such minor repairing works internally, started business in the said premises with the assistance of his partners in the said business, and the question of keeping the said premises under lock and key more than 12 years does not arise. Your client has falsely instructed you about such facts for some unseen reason without the knowledge and consent of other landlords of the premises.
So, if you come to the first line,
Yes, Millard.
said premises with the assistance of in the said business, a question of keeping the said premises under lock and key more than 12 years does not arise.
Yes.
This is not the contradictory to your statement made in the written statement.
No, they have said it is under lock and key for 12 years.
Correct.
So after my
82, 2014, as per your case, in the written statement, in the evidence, you closed.
Yes.
2014, you repaired and partnership went. So this is not your contradictory statement.
probably Millard, as I read this, Millard, this statement that the question of keeping it under lock and key more than 12 years does not arise probably indicates the period post 2014 after entering into the partnership. Well, that's how Millard I read it, because Millard
When what is the date of the notice? 14.
14.
Then
14.
how
the present status, as Millard would say, as the present status of the.
You have specifically stated the assistance of his partner in this business for keeping the said premises under lock and key more than 12 years does not arise. So as per your case, 81, 82, 9 months you run the business, you stop the business, you have some financial difficulty, then you started the business
2014. Yes.
So this is a contradictory statement of your defense which you have taken in the written statement and in the examination in chief.
But I'll just check below the specific allegation in the notice regarding putting it under lock and key. Well, here they have referred that since 1990 it is under closure. Page 326, their notice.
You have default in payment for more 20 days, that is from July 19.
July
So you were
1990, so I had a
habitual defaulter.
habitual defaulter in payment of rent and for closure of the shop
Hmm.
due to closing of it business.
Correct.
So, Millard, as I, Millard, would like to read it, Millard, when 2014 he is replying to it, he is saying that after induction of funds and partnership has been executed,
Hmm.
the question of further keeping it under lock and key does not arise.
Yes.
Probably that was meant to be stated.
Yes.
So, Millard, the question that it was under a partnership business was disclosed in a very early stage. It is not a defense which has subsequently been, Millard, planted as Millard
No, I am not telling the subsequent planted. You have, okay, you have mentioned the partners. Okay, then partners who are in possession of the premises, they have made a defendant number 2.
Yes.
And defendant number 1, defendant number 2 entered appearance.
Correct.
Defendant number 1 filed written statement. In the written statement, you have not stated that no, it is not a partnership with 1, it is the partnership 5, and we are getting, you have not disclosed that the 5 partners. That is my contention.
Millard,
It is not that you are surprised
Millard,
that the partnership.
Millard,
You have mentioned the
Millard,
partnership.
even then, Millard, as your lordship has observed, these are materials of record cannot be improved. Your
Correct.
lordship is absolutely right. But even then, it will be a case of incomplete disclosure, which will not take away my entire defense.
Why?
But once
You have to prove, if you are taking the plea of the partnership, you have to prove, yes, the partnership deed which you are taking the benefit of that has been given effect to. And how you will give the effect of the partnership deed? You have to prove, yes, this is the partnership, this is the business, this is the profit and loss, this is the tax, this is the tax payment, this is the receipt of the balance, and this is the monthly remuneration received by the partners. If this criteria, if you would have been fulfilled, then it can be said, yes, this business is running by the defendant number 1.
But Millard, I asked this to myself, Millard, in my cross-examination, when I was put into cross-examination, my defense that there was a partnership firm and that it was a business run by all the 5 working partners jointly. At least this much.
Okay.
This much was not
That I will take.
shaken.
That I have taken note of. What you have argued.
Has not been shaken by any of the statements in the cross-examination.
Thank you.
Now, Millard, once I say something in my evidence, and once, Millard, I am cross-examined, until and unless, Millard, my statement is shaken, at least to a substantial extent, probably your lordship would not disbelieve that.
Okay.
And Millard, I have shown that judgment, Millard, that paragraph, where the Honorable Supreme Court says,
Paragraph 19.
whether it is ostensible or not, whether it is a planted defense, maybe, Millard, discovered later, brought in subsequently, Millard would examine to that extent. Here, Millard would find from 2014 it was existent, and the suit was filed in 2015 itself.
Correct.
Anything
Anything further?
ওটাই থাকতো। Millard, let my learned senior friend conclude. Millard, I'll just place 1 or 2 more judgments. Millard, I'll just.
No, then he has to give the reply. What the
Millard,
judge will
I'll just hand over a copy. এটা পেয়েছো?
এটা কোনটা?
এটা যেটা দেখালো।
লিখে নিয়েছি আমি,
হ্যাঁ?
লিখে নিয়েছি।
আচ্ছা।
ঠিক আছে, ঠিক আছে। আমি তো কপি পড়া না।
Millard, this is 2004 4 SCC 794.
Yes.
Millard, para 8.
Yes.
Para 8 and 9, Millard.
Yes.
And Millard, para 9, Millard, and the last page, the second sentence is what, Millard, I am trying to harp upon. The existence of deed of partnership between the tenant and the alleged subtenant would not preclude the landlord from bringing on record materials and circumstances by adducing evidence or by means of cross-examination, making out a case of subletting or parting with possession or interest in tenancy premises by the tenant in favor of the third party. The
Yes,
rule
where-
as to
Where
exclusion,
from you're reading?
Millard, the last page of the judgment, the second sentence from the top. It is continuation of para 9.
Okay. Existence of the deed in partnership.
Yes, yes.
Yes.
Would not preclude the landlord from bringing on record material and circumstances by adducing evidence or by means of cross-examination, making out a case of subletting or parting with possession or interest in tenancy premises by the tenant in favor of third party.
Okay.
The rule as to exclusion of oral by documentary evidence governs the parties to the deed in writing.
Correct.
So once my partnership deed stands on record, just because I failed to bring on record additional evidence will not assist the plaintiff unless they check the fact that there was a partnership which was governing the parties.
Okay.
And this is 2010 1 SCC 217, para 25. Principal number Roman 5.
Yes.
ये लगी चीज। Para 25 Millard.
Yes.
The initial burden and shifting of the burden. Here the initial burden was never discharged, according to me.
Okay.
And from the materials on record. That it was sublet and the physical possession was delivered exclusively to someone, which is Millard the point on which I will be struck by the Premises Tenancy Act. Exclusive delivery of possession to a third party, that never Millard transpired in the evidence as such.
Okay.
And
That's all?
unless that is clearly discharged, Millard, the burden was not upon me to establish my case.
Okay. That's all?
That's all.
Thank you. Yes.
Yes, Lordship. Lordship,
Yes,
I will
Mr.
not take-
Bhattacharya, what is the matter?
One of the 41, 42, but is the motion matters, my lord, expert.
I'll
Absolutely,
not
madam,
take
I'm
much
here only.
time.
No, 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 madam, I'm here
That's
only.
fine. Lordship, I am, Lordships, I want to draw your Lordship's attention in the plaint. One, my lord, for a while. Page 2,
You are for the plaintiff.
and for the, yes, and for the plaintiff and for the landlord. Page 2. My lord, the case has been made out. Paragraph 5. That initially defendant number 1 was inducted as a tenant long back. This defendant kept this shop closed for a considerable period of time, and subsequently defendant number 1 in August 2014 illegally sublet the premises without consent of the plaintiff to defendant number 2, Dibakar Shah, grandson of such and such. For such subletting of the premises to defendant number 2 or hand over the same to the defendant number 2, who is running the business there illegally and has violated the prohibitions of the Premises and Premises and Tenancy Act, for which the defendants are liable to be evicted from the tenanted premises. So, Lordship, the case has been. For making out a case, a long paragraph is not required. Lordship. Secondly, if your Lordship kindly comes to page 10, that is the written statement of the defendant, the tenant, your Lordship has rightly observed the first paragraph that there is nothing with regard to the other alleged partners. They only said the partnership with the defendant number 2. Nothing is there. Now your Lordship kindly comes to the affidavit filed by the PW1, who is the plaintiff number 2. Lordship kindly comes to page 6, page 17. Here also it is very clearly, specifically mentioned, page 17. Lordship kindly come paragraph number 7.
Yes.
That initially the defendant number 1 as inducted as
This is your examination chief.
Yes,
Your examination chief.
examination of chief, that is page 17, paragraph 7.
Yes.
Last paragraph. That initially defendant number 1 was inducted as a tenant. Long back, this defendant kept the shop closed for considerable period of time, and subsequently defendant number 1 in August 2014 illegally sublet
The same as paragraph 5 of the plain.
Same, my lord.
Correct.
It has not been checked, my lord. Now, if your lordship kindly comes to the depositions, which has been, my lord, some of the portion has been skipped by my learned friend. That is, lordship kindly comes to the depositions of the DW1, the appellant before your lordship.
Yes.
Robindranath Ghosh. My lord, I am reading the entire deposition. These 2 depositions I will read because, my lord, he jumped some of the lines, lordship. DW1. Defendant, I am reading from the second paragraph.
Page 33.
Page 29, lordship. Kindly comes. This is the depositions of DW1, who is the original tenant.
Page 29. Yes.
Yes. I am.
Yes.
I am reading. Lordship, kindly allow me to read the entire depositions of the DW1 and DW2. I am defendant number 1 of this case. I have filed my evidence in the form of affidavit in chief. The said affidavit has been written as per my instruction. I have put the signature therein. After the contents were read over to me, as per the order of the court, I have deposited 20 years arrear rent, a rent of January 2016 amounting rupees 9275. I have deposited challan in court from the month of February 2016 to November 2017. I have regularly paid rent. I have deposited the challan showing payment of rent from February 16 to 17. Defendant number 2 is my business partner. This is partnership deed in between myself, Dibakar Shah, and the others, lordship. The deed was executed in the year 2014. I cannot tell the exact date. These are my signatures. I know the signatures of the rest partners. These are the signatures of the rest partners. The partnership deed is marked as X for identification, lordship. Thereafter, lordship finally comes to the pros. Name of my business is AP Garments. Apart from myself, such and such are the partners, including the defendant number 2. It is a fact that our partnership firm is not registered under Society Act. It is a fact that the trade license is in the name of our firm. It is a fact that tax book is in the name of our firm. Partnership firm started 20th June 2014. AP Garments is from the date of partnership firm started. Prior to AP Garment, I used to run stationery business in the tenanted premises. Only I used to run the stationery business. I ran the stationery business in the year 1981 to 82, about 8 to 9 months. Thereafter, lordship. What did you do in the tenanted premises from the year 1982 to 14? I kept the tenanted premises under lock and key. I am the sole tenant of the tenanted premises. From when are you depositing rent in the court through challan? I started depositing rent in the court from when I got notice of suit. Did you deposit the rent? Well, these are not so relevant. Deposit the rent from the year 82 to 14? No. I took possessions of the tenanted premises from Vijay Sarkar, original owner of the tenanted premises. Prior 40 years, I took the tenanted premises on rent from Vijay Sarkar. Did the terms of tenancy was reduced in writing? No. Did you file receipt in the court showing that you have paid rent to Vijay Sarkar? No. Did you tender the rent to plaintiff? No. Vijay Sarkar still alive. Did you make any agreement with the plaintiff for running partnership business? No. Did you seek no objection certificate from the plaintiff? No. Did you inform the plaintiff about the partnership business? Maybe I had stated in my WS that I have running the business in the name of AP Garments. But my lord, WS, there is nothing that they informed regarding the partnership business to the plaintiff owner. Thereafter, lordship finally comes to page 31. Leaving the first paragraph, in which year Ghosh status was changed to AP Garments in the year 2014. I informed Vijay Sarkar that I changed the nature of business. I did not inform him in writing. although Bijay Sarkar is not the, my lord, the landlord. Did you seek any written permission from the present landlord for running the partnership business? I do not know who was the present landlord. This is completely false because page 84, where my lord, the rent receipt where have been exhibited, where your lordship will get that the rent receipt has been issued in the name of the plaintiff.
No, rent receipt issue when?
My lord, page 84, lordship. I'm coming, lordship. Thereafter, lordships, the suggestions, lordship kindly comes to the next depositions of the next DW2, defendant number 2.
No, defendant number 2 filed return statement.
No, defendant number 2 not filed.
Not filed.
No.
So how if the
No,
return
my
is,
lord, I am
if the
coming.
defendant number 2 has not filed the return statement, how the defendant number 2 has been allowed to adduce evidence?
No, it was a common written statement by the 1 and 2.
Where is that?
So
It is
can
a
we
common
see the
written
written
statement?
statement?
Yes,
Page 7.
Is a common written
common
statement?
written
Yes.
statement. Common written.
Where? Can you see? Kindly come to the page 6.
Yes, common written statement. Page 8.
Page 8, Millard.
Rabindranath Ghosh and the
Written,
defendant number
written
2,
statement
Deepak Sharma.
submitted by different number 1 and different number 1. Page 8.
What is the page 6?
Page 6 is the, my lord, the application under
Acha, that, okay,
7.1
seven,
for
seven,
deposition of the
Okay,
rent.
okay.
Now,
And-
lordships kindly
And 7.1 was filed by defendant number 1.
defendant number 1.
And the return statement, okay. Next. Yes, continue.
Now, lordships, from the depositions and the cross examinations of the defendant number 1, my lord, it is very clear that there was no agreement with the landlord for running the partnership business. No objection has been obtained from the landlord. Nothing with regard to that he was actively involved with the alleged partnership business, not a registered partnership business.
Yes, continue.
Yes, lordship. So, my lord, lordship kindly comes now. Lordship kindly comes to the depositions of the DW2, with whose the alleged partnership business has been started by the defendant number 1.
Yes.
Lordship kindly comes to page 38.
30?
The cross examination.
Yes.
I am not related with Rabindranath Ghosh. He is not my relative. Lordship has got it. Sanjay Sarkar and Munju Sarkar has filed this case against me. It is correct that I did not enter into the agreement with the plaintiff of this case. I cannot say as to when the agreement was made in between the plaintiff and Rabindranath Ghosh. I cannot say as to any agreement at all was executed between Rabindranath Ghosh and plaintiff. It is correct that I am not the direct tenant of the plaintiffs. I did not inform plaintiff about the execution of deed of partnership in between myself, Rabindranath Ghosh, my wife, and such and such. And my hence, House of P.P. Upadhyay in Old Post Office, he has done the notary of the agreement of the at Kujbihar Barlai. So, my lord, he is the complete stranger. Lordship, and the agreement, my lord, the alleged partnership deed has been notarized, not registered, lordship. Now, lordship, kindly turn to page 39.
Yes.
Business of garments which runs as AP Garment. AP Garments is running since June 2014. The room where AP Garments is running was earlier in a dilapidated conditions. There was keys inside the room, also locked. I do not know as to whether Rabindranath Ghosh used to stay at Panipat, Vizag, New Delhi for the purpose of his service. And these are running the AP Garments after executions of the partnership deed. Now, your lordship, did you hand over the partnership agreement to the landowner? I did not hand over. I did not serve any letter upon the owner of the land regarding the formation of AP Garments. Our partnership firm has been registered by a notary. In Kujbihar municipality, there is a trade license in the name of AP Garments. I did not file the trade license in court. Is there any income tax file in the name of AP Garments? No. We did not file any balance sheet in the court in the name of our individual capacity. So a partnership deed, a partnership firm without trade license, without book of accounts, without balance sheet, and not registered. Now, my lord, we did not file any balance sheet in the court in the name of our individual capacity, not a fact that these are the suggestions, lordship. So, my lord, the partnership deed, which my learned friend is showing, my lord, it is admittedly unregistered partnership deed. My lord, the partnership deed has no trade license. The partnership has no trade license. There is no balance sheet. There is no books of accounts. So, my lord, my humble submissions before your lordship, it is completely the parting of the possessions under the guise of the partnership firm. Now, lordships, the observations of the learned appellate court, I will not read because my learned friend has already, my lord, read it. Lordships, I just lordship kindly, my lord, take into consideration of page 40, paragraph 23 is the observations of the learned first appellate court. Page 140. Page 140.
Yeah, that paragraph
Yes,
23.
Yes, lordship,
That is the only crux of the matter.
that is the only other we are not concerned with that.
Yes.
My lord, placing two judgments to your lordship. One is, my lord, a judgment of the honorable larger bench. Lordship, this is 19 at AIR 2004 Supreme Court 2299. Para 8, lordship. Para 8, I am reading, lordship. The rent control legislations which extend many protection to the tenant also provide grounds of evictions. One such ground, most common in all the legislation, is subletting or parting with the possessions of the tenancy premises by the tenant. Rent control laws usually protect the tenant so long as he may himself use the premises, but not his transferee inducted into the possession of the premises in breach of contract or the law, which act is often done with the object of illegitimate profiteering or rack renting. To defeat the provisions of the law, the device is at times adopted by unscrupulous tenants and the subtenants of bringing into existence a deed of partnership, which gives the relationship of a tenant and some tenant an outward appearance of the partnership, while in effect what has come into existence is substenancy or parting with the possession camouflaged under the cloak of partnership. So, this is the judgment of the 3 judges bench. My lord, thereafter, lordships kindly, taking into ratio of that, lordships kindly, I am hand over this judgment of the Honorable Apex Court, AIR 2010, Supreme Court 603. Lordship kindly comes to para 24 and 25. In this judgment, ratio of 2 judgments have been, my lord, taken into considerations, which are the larger bench judgment. Lordship, para 24.
24 is the replica of the
Yes.
Ravindran Singh.
Yes,
Ravindran Singh
yes.
judgment.
Now, lordship kindly comes to para 25. This is also the ratio of a judgment which has been delivered by the Honorable Larger Bench.
Yes.
My lord, the term sublet is not defined in this act, new or old. However, the definition of lease can be adopted mutatis mutandis of defining the sublease. What the lease, thereafter, lordship kindly comes, the sublease would imply parting by the tenant of the right to enjoy such property in favor of the subtenant. Now, lordship, thereafter, my lord, taking into considerations of all the judgments, my lord, a sum up has been made in paragraph number 28 of this judgment. The legal position that emerged, paragraph 28. This is the sum up of all the judgments.
Yes.
The legal position that emerges from the aforesaid decisions can be summarized thus. In order to prove mischief of subletting as a ground of eviction under the rent control laws, 2 ingredients have to be established. Parting with the possessions of the tenancy or part of it by tenant in favor of the third party with exclusive right of possessions, and 2, that such party with possession has been done without the consent of the landlord and in lieu of the compensations of the rent. So, my lord, in my case, my lord, they could not produce anything. My lord, the landlord, the plaintiff has discharged his burden. Now, lordship, they have expressed that they did not take any consent or no objection, nothing from the, so these two ingredients, my lord, have been, my lord, fulfilled in my case. Due to inducting partners or the partners in the business or the professions by the tenant by itself does not amount to subletting. However, if the purpose of such partnership is ostensible and the deed of partnership is drawn to conceal the real transaction of subletting, the court may tear the veil of partnership to find out the real nature of transaction entered into by the tenant.
So this is the clause 2. They
Yes.
have made out the case under the clause 2.
Yes,
Correct.
yes,
You are in clause 1.
yes.
Now the court has to decide whether your case is coming under clause 1 or the clause 2.
Yes. Now, lordship, what is ostensible? It is show off. My lord, a partnership deed which does not have any trade license, which does not have any books of accounts, which does not have any balance sheet. The partnership deed, which is, my lord, only notarized, not registered even, that, my lord, it can easily be presumed that it is not a genuine partnership deed, it's an ostensible partnership and the
But-
transaction is sham transaction. lordship.
Where is your suggestion in the cross-examination of the DW1 and the DW2 that this partnership only a sham document only to prevent themselves to be evicted from the premises? You have introduced the
That
partnership.
particular question has not been made.
Where is the
But
suggestion in
that
that?
particular question has not been made. But if your lordships go through its entirety, your lordship will get the questions has been made against which they have answered that nothing is there.
Okay.
Nothing is there. Now, lordships, if your lordships kindly permit me, my lord, I want to, my lord, show the, my lord, the act itself, my lord, in your lordship.
Which act?
The West Bengal Premises Tenancy Act, lordship.
Which clause you want to show?
My lord, I want to show clause 5 and clause 6. Section 5 and section 6. My lord, this is my book. It's
Ache.
My lord, I have 2 books. Lordship can take my book, but it is, my lord, underlined. I have 2 books. দিয়ে দিন কোনো অসুবিধা নেই কিন্তু একটু ধাক্কা বাজ Section 5, your lordship.
Yes.
Kindly comes, lordship, kindly pardon, my lord, the books is, my lord,
Yes.
highlighted and the star, all these are there, my lord.
Yes.
My lord, section 5. Every tenant shall pay to the landlord or his authorized agent within the prescribed period. 5.2. Every tenant shall use the premises for the purpose for which it was let out to him. Now, lordship kindly comes to 5.5. No tenant shall sublet the premises without consent of the landlord in writing.
Yes.
No tenant shall, without the previous consent in writing of the landlord, transfer, assign his right in the tenancy or part thereof.
Yes.
Now, lordships, I am drawing your lordships' attentions in section 6. Section 6, 1A. Where the tenant has sublet, assigned, or otherwise parted with the possessions of the whole or any part of the premises without obtaining the consent in writing of the landlord or me, tenant has used the premises for the purpose other than that for which it was laid out without obtaining the consent in writing of the landlord. Now, if lordship kindly comes, where the tenant or any person residing in the premises laid out to the tenant has done any act contrary to the provision of the clause M, O, clause P of section 108 of Transfer of Property Act. Now, my lord, section 108 of Transfer of Property Act, my lord, what says, lordship?
Yes.
Huh? Section 8O, section 108O. My lord, I'm reading thereafter, I'm giving this book,
Yes,
my
yes.
lord. The lessee may use the property and its product, if any, as a person of ordinary prudence would use them if they were his own, but he must not use or permit another to use the property for the purpose other than that for which it was leased.
Okay.
Now, lordship, the judgments with my learned friend, my lord, has been, my lord, mentioned before your lordship, the first one, which is 1987 3 SCC paragraph, page 538, para 19. What I have, my lord, understood in my little knowledge, that the sharing of profit of partners is to be considered in the partnership. But your lordships has rightly said that where are the other partners, my lord? Nothing, my lord, in their written statement. And my lord, no account, books of account wherefrom, my lord, the conclusion can be made that the profit has been shared between the partners. So this judgment is not applicable in this present case.
Yes.
2004 for SCC 794, my learned friend lordship has, my lord, mentioned. Well, my lord, I differ from this judgment because, my lord, the evidence adduced in the cross-examination and the way the evidence has been come out, my lord, it has, by which, my lord, the plaintiff has discharged his duty, his burden has been proved, my lord, discharged. And also, my lord, 2010 1 SCC 2017, my learned friend has handed over. My lord, to this regard, I will say that initial burden has been proved by the plaintiff.
Yes.
By the way of cross-examination, my lord, of defendant number 1 and defendant number 2.
Yes. That's all.
Yes, sir.
Yes.
Just 2 lines. my lord.
Yes.
We're subletting by way of delivery of physical possession to a third party in exclusion of the original tenant or someone other than the original tenant. This is where, Miller, they have faulted. There is no evidence to suggest that has at all occurred. 2, as Miller has rightly pointed out, that the partnership deed was a sham transaction or Miller, an ostensible one to create a cloak to get away with the mischief of the act. That is, Miller, a third case made out by the appellate court on the first place, not before that. It never came up before the trial.
My lord, I'll
Thank
say one line.
No
Page-
reply. And
My lord, page 84.
yes.
My lord, where it has been clearly stated,
Sharanya,
on perusing Exhibit A series, it appears that the defendant has submitting rent in the name of the present plaintiff.
no, I'm not on that. I'm not.
That
on
is
that.
not.
I'm not argued that also.
Grateful, your lord.
তোমার
Yes.
status challenge করে নিতে হবে।
Hearing concluded. CAB. Thank you.
Grateful, your lordship. Our pleasure, my lordship.
এটা রাখ- Still going. Yes, next. All the next. 5.
Hearing on behalf of the petitioner. Today, she called on the matter and I was handicapped and not
Yes, what is the matter? Who is for the other side?
on the other side of the particular that served.
Where is the affidavit of service?
Affidavit of service will be accompanied.
Yes.
But yesterday he was present.
Hmm.
Yesterday he was present.
Where is the impugn order?
Under the order, will discuss it for declaration, permanent injunction and other consequences.
Hmm.
Whereby and wherein. Time keeping.
Hmm.
Well, this is suit for declaration and permanent injunction, Malad,
Hmm.
and with other consequential release.
Hmm.
Malad, in this Malad, I have filed the order 7/2011, Malad.
Hmm.
So this is the affidavit of service. That was the last direction of the Honorable Court will have served upon.
Yes. You are for the defendant.
Yes, I am the defendant.
Ah.
I'm the petitioner defendants. Malad, in a suit for declaration of permanent injunction.
Hmm.
And order 7/2011
You
was
filed-
rejected.
You filed the order 7/11.
Yes.
What is the ground on what?
It is barred by limitation, law of limitation.
Hmm.
And I'll
And?
agree with your lordship,
But by limitation and
barred by limitation.
Only.
That was
the major point.
Okay.
That was the primary point which was taken in the orders from rule level application.
Hmm.
Other than that, my lord, there is also one more ground that is there.
Hmm.
That is a bar under section 34 of the specific relief act 1960.
Hmm.
My lord, now the suit is for declaration that the plaintiff are the owners of the property. The second declaration is that the defendant society is not the owner of the property. Third is for permanent injunction and other consequential reliefs are attached to the claim. Now, my lord, I have, my lord, threefold arguments with your lord. The first argument would be, my lord, that despite having knowledge of the sale deeds that were executed in my favor, the plaintiff could not have filed the suit without challenging those sale deeds. And where the sale deeds have admittedly been accepted and mentioned in the claim. So without challenging or seeking for a prayer for cancellation or void ab initio, whatever it is, as the case may be, without those prayers and without those averments, the suit would not have been framed in such manner. That's the first point. The second limb of argument is that because they have not fought for any declaration or for declaration for cancellation of the sale deed.
So as per your case, you are having the deed
Yes, sir.
in your name
Yes, sir.
by executed by
One Madhav Chandra Paul.
who is
I
he?
will appraise your lordship with the entire genealogical table, whatever is there, my lord, I'll appraise your lordship. And that is certainly the plain case. That is certainly the plain case also. So, my lord, the first limb of my argument is that there is no challenge to the sale deeds that have been executed. Why there are no challenges to the sale deeds that have been executed? Because if those sale deeds were under challenge in the suit would have been barred by limitation.
Correct.
That's number one. Number two is
So
yes, ma'am.
if you have relied upon the deed, you have relied upon
No,
that.
I have not relied upon it. It's their admission. It's the plaintiff's suit.
That's a where is that?
Yes,
Show me the
Paragraph
government.
6 of the claim. But I also say that this is clever drafting.
Correct.
And clever drafting, if some suit is there with clever drafting of this sort, Miller, then that suit has to be nipped in the bud. Miller, kindly, first, Miller, kindly comes to the claim starts at page 60.
Yeah.
I would take your lordship to the entirety of the claim, but before that, Miller, I would invite your lordship's attention to page number 19 of the civil litigation application. Miller,
Yes, come to paragraph 6.
paragraph 6.
Come fast.
Yes. That thereafter Madhav Chandra Paul executed 3 deeds of sale bearing number such and such, such and such, and such and such,
Correct.
and in favor of defendant society, and thereby sold a substantial area of land to the defendant society under different plots.
Correct.
However, neither Joyashree Singha nor her legal heirs, that is the plaintiff, ever sold any portion of the land to Madhav Chandra Paul in respect of such and such plots.
Correct.
So, my lord, they have admitted the existence of and the execution of the deeds. So, my lord, the first point is that sale deeds are required to be mandatorily registered under the Registration Act, read with section 54 of the Transfer of Property Act.
Correct.
So, my lord, the constructive notice of the existence and the execution of the deed starts from the date of registration and not from the date of knowledge.
Correct.
This will be my second limb of my argument. And the third limb.
No. Kindly come paragraph 6.
Yes.
Madhav Chandra Paul executed 3 deeds. Correct.
Yes, madam.
In favor of the defendant society and thereby sold the substantial area of land to the defendant society under the different plots.
Yes.
However, neither the Joshwari Singha nor her legal heirs, that is the plaintiff, ever sold the portion of the land to the Madhav Chandra Paul. So you mean to say once he has admitted with regard to the 3 deed in your favor by the Madhav Chandra,
Yes.
but he is claiming the right over the property, telling that they have not executed the agreement, so they have to challenge your deed first, then only the cause of
Yes.
action arose.
Otherwise, they cannot.
And that is occurred in 2015. Now we are on 2000 when the suit was filed.
Suit was filed in the
2026.
2024.
24.
24.
Okay.
This suit was filed on 2024, and that is why,
Okay.
in light of the judgment passed by His Honorable Supreme Court,
Yes.
Jaiben's case, Malad is aware of that judgment. It is a complete bar under the Limitation Act, and hence this suit does not lie.
Yes.
One more thing I would point out to your lordship, Malad, kindly comes to page 17 for once. Malad, this is a suit simpliciter for declaration and permanent injunction. And Malad, they have framed this suit and they have paid the court fees of ₹80,000. This is abuse of process of law. This is forum shopping, and this kind of practice of taking this suit
Which
to
court
a
it was
higher
filed?
forum.
Which court it was filed?
Malad, it was filed before the Learned Civil Judge Senior Division. at
Civil Judge Senior Division having the pecuniary jurisdiction of
88. Malad, it has the jurisdiction, but Malad, for declaration and permanent injunction, 80,000 court fees is not required in my humble and respectful submission. It's 100 and 100. That's 200. So it ought to have been filed in the junior division.
if the party has paid the excess court fee, what would be the result? What would be effect?
Forum shopping.
What is the would be the effect?
Malad, effect would be I can take a preliminary objection.
I am asking the simple question, what would the effect?
And effect would be.
See, this court is having the 10,000 rupees jurisdiction.
Yes.
Correct.
Yes.
And the plaintiff case is and the pecuniary jurisdiction of the suit is valued of 5,000.
Yes.
If we filed in the 10,000 jurisdiction having, what would be the effect of the suit?
Effect of the suit would be claim would be returned to the.
That's all.
Before the appropriate forum.
Correct. Correct.
Yes.
So that will not amount to Order 7 Rule 11. So this is an order. That's why I'm asking from your mouth. Yes,
And-
next.
Yes, sir. Now, kindly, Malad,
So this is a paragraph 6. He has not challenged this deed.
not calendar.
Now what is the second?
Paragraph number 6 has to be read with the
Correct.
prayers,
Yes.
Malad.
Hmm.
Kindly comes to the prayer. Declaration. Declaration that the defendant society associate So one may I just hand over your lordship the deed? May I?
Why you not disclose the order, sir?
Was not there at that point in time.
What?
These deeds were not there with me at that point.
So if you file the Order 7 Rule 11, how this court can go into in the revisional jurisdiction?
Because they stated it.
Sorry. You filed, that's why yesterday I also told you, you filed Order 7 Rule 11. Order 7 Rule 11 with regard to the plain. If you're relying upon some document that the court cannot go into the revisional application document.
My lord, the documents were referred to by the, in the impugned order by the court. Trial court. My lord, kindly come.
No, this is the first call. Where is the second aspect? This is the only aspect?
Yes, sir.
Okay. Now the order.
only aspect is, my lord, the suit is barred under the.
Correct. That is the only, because 2015 there is a deed admitted. He has not challenged your deed and claiming his declaration was the property. This is the case. Yes. Come to the
My lord,
order.
kindly comes to for once, my lord, page 2 of the impugned order.
Yes.
Impugned order at last, my lord.
Page 2.
Page 2 of the impugned order. The deeds have finds place in the impugned order itself.
Yes. Yes.
But second last.
No, that is paragraph 6 given the details of the deed. There's
Very
no,
good. I
there's
would
not,
trouble you, Lord.
not required, not required. But how the trial court has dealt with?
Trial court has dealt with.
Where is which paragraph? How the trial court? What is the observation of the trial court?
The trial court has observed
Lordship, running page 6 of the judgment.
from 5 onwards, the trial court's observation starts. my lord.
That is order 11 rules 7, order 7 rule 11.
my lord, the
Then-
order-
Then
from 5, page 5, my lord, findings are there.
The relevant part is that, my lord, on
Lordship.
page 6, last paragraph.
Page 6, last paragraph.
Second last paragraph, Lordship. Second last paragraph.
Please, I will hear you.
Lordship,
Please, take your seat. Yes, well, let he satisfy, then I will come to you. No problem. Yes.
Very well. If my learned friend asked me to place paragraph, second last paragraph, I am placing from that. From the contention of the defendant, it seems that the defendant have challenged the plaintiff on the ground of non-disclosure of date of knowledge of the plaintiff in respect of the possession of the land by the defendant, which the plaintiff claimed to be the actual owner of those land, and thereby has challenged the claim for want of disclosure of cause of action, which triggered the defendant to challenge the claim of the plaintiff. But from the rival contention and plain reading of the claim, it clearly reveals that the claim has actually disclosed the material facts which caused them to come to court to seek relief for declaration in respect of the suit property. Since the scheduled suit land includes the bulk of plot of land which are as the alleged assertion of the plaintiff, neither the predecessor in interest of the plaintiff nor the plaintiffs have any right to transfer the defendant. In the present case, from the contention of the application under consideration, it appears that the defendant have placed assertion under the provision of Order 711D. Only challenging the suit is barred by the law of limitation, and thereby have specifically challenged that the plaintiffs have suppressed the actual date of knowledge when the cause of action arose. It means that the defendant did not deny that the plaintiff have not disclosed any cause of action. In that way, it can be presumed at this stage, while disposing of an application under Order 711, the court has no scope to look into any other alleged fact raised by the defendant, save and except the averments and the pleadings of the claim. But the paragraph 6 is not out of it. Next, all the judgments have been cited. Kindly comes to paragraph, number, page number 8, last paragraph.
Yes.
From the plain reading of the claim and pleadings, it appears prima facie that the plaintiff has instituted a suit basing upon the knowledge of the alleged fact of enforcement of scheduled suit land by the defendants, which, as per the allegation of the plaintiff, the defendants have no title over the same, and this fact dragged them to institute this suit. Well, now relates back to paragraph number 6.
Correct.
The alleged fact that whether the plaintiff have got the actual knowledge of the same in the year 2015 or sometimes in the year 2014, when the alleged encroachment by the defendants was actually made, is subject to evidence. At this stage, as the pleadings prima facie discloses some fact which entitles the plaintiff to initiate proceedings against the defendant, especially when finally turns over, the defendants did not specifically challenge the said alleged facts. No question of filing the suit, thereby
Barring the plaintiff
comes into operation. The question was debarred the plaintiff to raise objection as to the date of limitation to institute this suit against the defendant is also subject to evidence, and at this stage the said fact cannot be taken into account for consideration while the court is adjudicating an application under Order 711. Although by challenging the instant suit, the defendant have argued that the suit is barred by limitation, but the said fact also cannot considered and determined at this stage, as the plaintiff have filed the instant suit basing upon their actual knowledge of the alleged fact when the plaintiff itself discloses a valid cause of action. Now, my lord, this is the observation, my lord, and then with all these observations, stating that the question of limitation is a mixed question of fact and law.
Correct.
The Order 711 has been dismissed.
Correct.
Now, I would, my lord, with your lordship's kind consideration, I would place some judgments. First of all, my lord, I would.
You tell me, yes, with regard to the 3 dates, what is the total area of each land, and total area has been purchased by you?
Total area has been purchased?
Total area.
Yes. Deeds are there.
No, that's what I'm asking, because the plaintiff has made out a case that you have started encroaching upon the property. Because he has not challenged your deed. This is your contention, he has not challenged
That
the
is
deed,
what-
and you become the owner of the property in terms of the registered deed, which is admitted in paragraph 6.
Yes, my lord.
And paragraph 6 contains several plot numbers.
Yes, my lord.
Correct.
Yes, my
And
lord.
that plot number is also in the schedule A, B, C, D, E. Correct.
Yes.
Now the plaintiff has made out a case in paragraph 11, then paragraph 18. The plaintiff are the rightful owner of the property, and they have been possessing the suit property, paragraph 18, since long. On the other hand, the defendant has no valid piece of the document, but intends to occupy the suit property by its own gain. The interference by the defendant society, peaceful possession. So they have made out a case that you wanted to interfere with the possession of the plaintiff's property. That's why they came to the court claiming the declaration they are the owner of the
Yes,
property.
my lord.
Correct. So now though they have admitted with regard to the deed, and the deed consisting of the survey number, I don't know, because they have not clarified in any of the prayers, in any of the paragraph, except the 18, which property you have encroached. That is the matter of trial. Correct. And the deed which you are telling that you have purchased the total property or half property or 1/3 property, that is a matter of trial. So how the order 7? So where is the illegality in the order passed by the landed trial court?
With my submitting, my lord, there is illegality because my lord was talking about paragraph 18. 18 and 6 are mutually destructive, my lord.
Correct. That's why.
Yes.
So if it is destructing, whether destructing pleading can be taken into consideration under order 7/2011.
Now let me place the judgments for once, for my satisfaction. My lord, first, my lord kindly takes up the Transfer of Property Act for once.
Yes, which section you are online?
Section 3.
Yes.
Section 3, definition of notice.
Hmm.
A person is said to have notice of a fact when he actually knows that fact, or when, but for willful abstinence from an inquiry or search, which he ought to have made, or gross negligence, he would have known it. Now, let explanation 1 is there, explanation 2 is there. 3 explanations are there, my lord. I need not read all the explanations because it will unnecessarily waste your lordship's time. Now, my lord, keeping in mind this section, the definition of notice, my lord, I want to cite a judgment on this.
What definition of notice? What you want to corroborate definition of notice?
Yes, sir. I'm so grateful. my lord.
What you want to corroborate from
Now,
the?
on this, in light of this definition of the notice, my lord, I want to argue that once a deed, a sale deed, particularly a sale deed which is compulsorily registrable under the Registration Act and under the TP Act under section 54, otherwise the sale is not complete. Without registration, a sale is not.
See, that's again I am telling you, with regard to the deed, they have not challenged your deed.
Not at all. my lord.
Correct. They have not challenged. It is not that they have challenged the 2015 deed in 2024. This is not the case here. They have admitted that Madhava has executed a deed in favor of.
Then they must have challenged.
Correct.
That's what I'm
They
saying.
have not challenged.
Not challenged.
If
must
they
have-
have not challenged, they have made out a case in November 2024. They came to know that the defendants are occupying the property of the plaintiff. So that's why they have made out a case that the declaration.
Yes.
Correct. So if they have made out a case the declaration, then it has to be decided whether they is having the right of the property or not, and whether you have encroached or you have tried to encroach or occupy the property of the plaintiff.
There is no case of encroachment at all.
Kindly come. That's why.
Yes.
kindly come to the paragraph 18.
This is why I say that, my lord, this is intelligent, clever drafting.
Maybe
See,
the
simply clever
advocates, even only because of clever drafting, so order 7 rule 11 cannot be taken.
My lord, there is humbly and respectfully submitting, my lord, there is a judgment.
Yes, I know.
As well. Your lordship knows that very well.
But here kindly keep it in mind, 2015 deed he has not challenged in the suit.
No, he must have challenged.
Can you force?
Yes, my lord.
Can the court force you challenge?
I cannot force, but under the law, he must have challenged. This is my argument.
So that will be your defense in that recognition.
Kindly see.
That will be a defense.
Kindly see. In this, my lord, a partition suit was filed, my lord. Order 7, Rule 11 was filed in this partition suit. Same question has arisen, my lord, whether the sale deeds were under challenge or not, and the same point of limitation was raised. Trial court allowed the Order 7, Rule 11. High Court has reversed it, sent it back for remand, and then the Supreme Court has affirmed the trial court's order, saying that no, the trial court was right in holding and allowing the Order 7, Rule 11, stating that the sale deeds were not challenged, they were barred by law of limitation. My lord, kindly comes to
Judgment a copy citation কিছু দিতে হবে
2025, Volume 5, SCC, page 198. My lord, kindly comes to paragraph 11 directly. Paragraph 11. The sole argument advanced by the respondent plaintiff is that the suit was only for partition filed in the year 2023 and was within the limitation period, as limitation will be counted from the date of their knowledge of the sale deed.
Correct.
However, upon examining the pleadings before the trial court and the appellate court, it is evident that the plaintiff failed to address the crucial question of when they became aware of the registered sale deed. If they had prior knowledge of the sale deed, they failed to specify the exact date of such knowledge, such is in this case also. Additionally, the pleadings suggest suppression of essential facts by the plaintiff.
Correct.
Now, my lord, kindly comes to, I will skip over the next paragraph, my lord. In paragraph number 13, my lord, is very important, which refers to Suraj Lamp and Industry.
That is registration.
Yes, my lord, that's a reported decision, my lord.
That is a registration of the document.
That's exactly what I wanted to say, my lord. Registration.
That's what, sir. That is not a dispute. Admitted fact can be a dispute.
Not at all, my lord.
So,
That is where I am.
paragraph 6, they have admitted.
Your lordship, kindly give me some time to.
Because this court is not having so much. Once it admitted,
I
why the
understand.
court?
I understand.
Yeah, kindly come to other.
Yes.
Once they have admitted, can you again put that question?
My lord, kindly comes to paragraph 14 forward.
Yes.
Applying this settled principle of law, it can safely be assumed that the predecessor of the plaintiff had notice of the registered sale deeds flowing from the partition that took place way back in such and such.
Correct.
By virtue of them being registered documents. Now, my lord. Yes, this is what I wanted to show it to your lordship, that when the moment the document is registered, knowledge starts from there. So, my lord, if knowledge starts
What?
the moment the document is registered.
If the party is not the party to the registered document, how you can say? If what you are making the summation, if the parties to the deed and one party challenge the deed, then it can be said that they had the knowledge.
Excluded and non-excluded.
Yes, if the person is not the party to the deed, the knowledge will come when he has to prove when the knowledge comes.
My lord, if my lord comes to the very next paragraph, paragraph number 15.
Yes.
The learned senior counsel of the appellant defendant, Mr. Such and such, relied upon such and such, paragraph number 22. Then in paragraph number 15 only, that citation at paragraph number 20.
Yes.
When a portion of the property has been conveyed by court auction and registered in the first instance, and when another portion has been conveyed by registered deed in 1952, there is a constructive notice from the date of registration and presumption under section 3 of the Transfer of Property Act comes into operation.
Correct.
The possession in the present case also has been rested with the appellant before several decades, which operates as notice of title.
Correct.
Continuing further with the plea of limitation, the courts below have held that the question of the suit being barred by limitation can be decided at the time of trial as a mixed question of law and fact. Though the question of limitation generally is mixed question of law and fact, when upon meaningful reading of the claim, the courts can come to a conclusion that under the given circumstances, after dissecting the vices of clever drafting,
Correct.
creating an illusion of cause of action, the suit is hopelessly barred and the plaint can be rejected under Order 7 Rule 11.
Correct.
This is where I'm on. This is specifically where I'm on.
Yes.
Now, my lord, kindly, paragraph on that page only the last 3 lines. If clever drafting of plaint has created the illusion of cause of action, the court will nip it in the bud at the earliest, so that bogus litigation will end at the earliest stage. But this is what I wanted to submit from this judgment.
Yes.
My lord, next is, my lord, I'm giving both the judgments together, my lord. One is, my lord, Justice Krishna Iyer's judgment, my lord, that I have argued that clever drafting has to be looked into.
Yes.
And if there is a clever drafting found in the plaint, for such recalcitrant litigants, my lord, only one consequence is there, that is rejection of plaint. So in my humble and respectful submission, this is absolutely clever drafting and this should be nipped in the bud. Now, my lord, kindly takes up the Dahi Ben's judgment, which is there, my lord. This judgment was referred to in the impugned order. Although it was referred to in the impugned order, this judgment of Dahi Ben, my lord, passed by the Supreme Court, was not taken into consideration and not dealt. And that is where the irregularity lies. That is where the irregularity lies. Now, my lord, kindly.
Citation. ये तो बोलते आ रहे हैं. You should get.
2020.
Yes. Which paragraph? Which paragraph?
2020, Volume 7, SCC 366. And 1977, Volume 4, SCC 467.
Which paragraph you are relying upon?
Yes, ma'am. Well, kindly directly comes to paragraph number 14. Paragraph number 14, Lord, is the submission. Yes, ma'am. Paragraph number 16. Kindly comes to paragraph number 16. The trial court held that the period of limitation for filing the suit was 3 years from the date of execution of the sale deed. The suit was filed on 15th of December 2014. The cause of action as per the averment in the plaint has arisen when defendant number 1, respondent number 1 has issued false and bogus checks to the plaintiff in 2009. The suit for cancellation of sale deed dated such and such would have been filed by 2012 as per Article 58 and as per Article 59 of the Limitation Act. The suit was, however, filed on 15th of December 2014,
Yes.
which was barred by limitation. Now, my lord, kindly comes to paragraph number 20.
But,
is the
but
observation.
this is not under 711.
My lord, this was
This is after trial. Paragraph 16, what says?
paragraph 16 says about the limitation period.
The trial court held.
Yes, my lord, trial court held, but it was.
Whether it was before trial, at the time of trial.
Yes, my lord. Kindly comes to paragraph number 1 of that judgment. The present civil appeal has been filed to challenge the impugned judgment and order dated such and such passed by the division bench of the such and such High Court, which affirmed the order of the trial court allowing the application filed by the defendant number 2 and 3, respondent number
Yes,
2 and
711.
711.
Yes.
11D.
Yes. Next.
Yes, my lord. Paragraph number 20 for once. The division bench of the High Court took note of the fact that the plaintiff did not deny having executed the registered sale deed dated 2nd of July 2009 in favor of respondent number 1. In the said sale deed, it was specifically admitted and acknowledged by the plaintiff that they have received the full sale consideration. The sale deed contained the complete particulars with respect of the payment. This what I am reiterating is, my lord, what I am trying to submit is that there was knowledge. And in this case also there is knowledge. Express knowledge is there because of paragraph number 6 of the claim.
Okay.
Next, my lord, paragraph number 25. Paragraph number 25, my lord, the limitation period has been dealt with.
Yes.
Yes, ma'am. I'm just quickly going through the paragraph without wasting a lordship.
That is the limitation act. Next.
Yes, my lord. Next, my lord, I would refer to, my lord, paragraph number 29.17.
Yes.
Before that, may I show your lordship paragraph number 29.13. This talks about the conduct of the plaintiff.
Yes.
The conduct of the plaintiff is not taking recourse to legal action for over a period of 5.5 years for the execution of the sale deed in 2009 for payment of balance sale consideration also reflects the institution of the present suit is an afterthought. So this is also an afterthought. Now, my lord, I would quickly jump to, my lord, paragraph number 29.17, which I was showing your lordship. This is the concluding part of the judgment. The plaintiff deliberately did not mention the date of registration, date of registered sale deed. Your lordship, got it?
Yes. Yes.
Yes, very good. Sale deed dated such and such executed by them in favor of respondent number 1. Since it would be evident that this suit was barred by limitation. This is the case. Here also, it is the same facts and circumstances. They did not do so because of.
Why you are telling? Paragraph 6 is admitted 2015. How you are telling that 2917 is applicable? Paragraph 6 is admitted 2015 deed. So how the 2917 is applicable?
Thereafter, paragraph number 29.18 is also the.
Yes. Next, anything further? That's all. Yes. Now you come to paragraph 18. Paragraph 18. Which date you came to know that they have occupied the property? I am asking one question. Paragraph 18 is your case. Kindly show which date you have you came to know the defendants are occupying your property.
They are trying to occupy.
That's why which date?
Paragraph number 15, 26/6/2024.
26 defendants labor similarly. Okay. So now okay. Now paragraph
16.
Yes, I got it. Now you come to the which portion? What is the area of your property? What is the area of your property? You are the owner of the property. You are telling that the defendants tried to occupy your property. Now you come to your plaint and show any paragraph. You are the owner of the property.
Paragraph number 11.
Paragraph 11. .72 decimal of RS plot number 339. Correct. This is your property. So 339 is not the property of the deed. Sir, with the RS plot number 339 corresponding RS plot number 737, 738, 739. Khatian number 48.
I have total number of 5 schedules in this plate, A, B, C, D.
No, I am asking one question. You have in paragraph 6, you have admitted 3 deeds.
Lordship,
You admitted.
let me clear just one point. Lordship, this property actually was from Dharmakanta Singh.
Correct.
Dharmakanta Singh died. Thereafter, the property.
Who?
Dharmakanta Singh.
No, Dharmakanta Singh. Yes.
Dharmakanta Singh.
Yes.
He died. Thereafter, the property was with Joeshwari Singha, who is
Yes.
the mother of the present plaintiff.
Hmm.
Lordship, Joeshwari Singha has sold this property. Out of the total property, they have sold only 11.33 acre of land, which is at paragraph number 4, Lordship.
Jai Singh executed 2 deeds of the sale bearing 5294 and 5295. 7074 thereby sold the transfer the measuring itna area to total itna registered sale deed to whom?
To Lordship Subal Chandrapal and Kalyan Ranipal.
To Subal
Kalpana
Chandrapal and Kalpana Ranipal. Paragraph 4.
Paragraph.
Correct.
Lordship, thereafter this remaining portion of land.
Hmm.
18.7 minus.
So out of 18.7,
Seven.
you have sold 11.33. You have sold 11.33.
Sold.
Correct. Correct. So 6.84 you are having with regard to the which plot number? Which plot number?
Various plots.
This one, paragraph 4. Paragraph 4, which plot number?
Lordship, the plot numbers are. Lordship, plot numbers are RS plot number 563.
Huh?
RS plot number 563.
563. Where is the sale deed of the 5294 and 5295? Have you disclosed this sale deed?
Lordship, that has been filed. Lordship.
Where is that deed?
Their case, they have ought to have filed. Lordship. With the.
So 5294, where is the list of documents in the plaint?
Lordship, list of documents is filed separately. Lordship. With the plaint goes itself, Lordship, the list of documents is filed separately with the post below.
You are filing the suit.
Lordship.
Along with the suit, there is a registered address of the parties,
Lordship.
list of documents.
Lordship.
That's why I'm asking, where is the list of documents?
Lordship, list of document I had filed in the court below, Lordship. But
Yeah.
they ought to have annexed that. They have not annexed it.
Who will annex?
Lordship, it is.
Who is the plaintiff?
I had annexed it in the trial court.
So that's why I'm showing where you might have been original, you might have been in plaint. Where is the list of documents?
Lordship, I am not the lawyer in the trial court.
That is the problem.
That document is not with me. If Lordship allows, I will bring the document.
I have the deeds. I can hand it over to you.
Which one? 5294? 5294 and 5295.
What is it? At page one.
Page 19. Page 19, paragraph 4.
Those deeds are.
That's why, because now he is making out a case.
I'm having these deeds in paragraph number 6.
Six that. No, but he is telling 1974, these are the two deeds. That deeds containing the 536 and all these things which you have purchased subsequently in 2015. He is telling that 74 on 11 point. Okay, then.
Then Lordship, this property was sold, the remaining portion I was enjoying, Lordship. My predecessor was enjoying, thereafter I.
Okay, in that case, now can you come to the schedule of property?
Lordship.
If you're on that, now you come to the schedule of property. Where is the schedule of property?
Lordship, at page number 24.
24. Correct. Where is the part where you mentioned that the part of the land bearing survey number? Where is the you are asking the total property?
No, Lordship.
Kindly come to the schedule A.
Lordship.
Piece and parcel of the land measuring an area of 12.
12 decimal.
12 decimal.
It was acre. 18.17 acre means 1 acre.
So you are asking. So you are asking 12 decimal
12
and
decimal, thereafter
57.
decimal,
Then
thereafter, Lordship,
188 decimal.
Thereafter, Lordship,
122 decimal, 72 decimal. So what would be the total acres?
Lordship, I'm doing, Lordship, I'm calculating. 12, 57, 8, 122, 72. 4.5.
4.51 hectares. So here is a 6.84. Correct. So one thing. So and the deed which you are mentioning in the paragraph 6, the deed containing which how many areas?
Lordship, that is 18.17 acres.
Huh?
That is the total area, Lordship. They have their predecessor has them transferred the entire land, which actually didn't belong to them.
That is different thing. That's why if you go by then your suit will be out.
Lordship, the only contention is that I was enjoying my land. They had purchased.
That's why you have to make out the case which portion of the land.
Lordship, this is.
Where is that? Show me.
Schedule is clear, Lordship, the portion of land.
Where's the paragraph?
Lordship, kindly see the paragraph number 7, 8, 9, 10 and 11. I have elaborately discussed about my land.
Where you mention the plaintiffs are the owner of 12, 57.
Then after 57, then 188, then 122.
So you are having the deed of 5294 and 5295 and 987,
Lordship, my predecessor.
I am asking three things. These two deeds you are having 5294, 5297, 5294 and 5295,
I have to ask.
and the other two deeds, the three deeds of his 9887, 8358 and 9889. These three deeds you are having.
Must be having some.
You produce by supplementary affidavit tomorrow.
By tomorrow, it will not be possible. Kindly give it to Monday.
So bring the date, this date and that date.
Malad kindly allows me also to produce the file a supplementary affidavit with respect to this paragraph 26.
That's why I'm asking. If they will not, then your deed will be taken because they are the plaintiff. Let them produce. They are admitted. Let them, because now they have making out the case out of that property, the 678, that is 4.1 acres, that is still with them. So now the court has to see if the registered deed of yours and 5294, 529, 1974 is the total has been sold out, they will be out.
Really, even if they show it, they have to get out of all these judgments that are.
No. That is the evidence. That is the matter of trial. That's why I want to show he is claiming that 4 paragraphs, 4.67 acres. Correct. And the total of the 18.7 acres something is there. So they have admitted with regard to the your deeds. He is admitting other 2 deeds. So he's done other than after deducting the property, they are having the possession.
And two things I would like to say. All the judgments my direct friend has said, in those judgments, these were either executed by the respondents or
No. His main contention is that once you have admitted the 3 deeds, and his contention is that as per that 3 deeds, the total land has been sold it out in 2015. And you have not challenging the deed because in paragraph 6, you're telling that you have not sold and Madhav was not the owner of the property you can sold. So as per the contention, you're telling that the deed executed in favor of the defendant, that is the third person has sold the property who was not the owner of the property. But you are not challenging that deed.
because
So that's why,
because Lordship, I have not executed.
if you're not executing, but you are claiming the title of the property, declaration of the property or the property. So if you are claiming the declaration of the property, so first you have to prove your title over the property, then only the declaration will come.
Lordship, that has to be done in the trial, but Lordship,
That has to be brought on record. The plaint case has to be made out. If the plaint case is not made out, how you can prove? How you can prove in the evidence? That's why I'm again and again asking.
kindly comes to this judgment once.
Judgment time will come.
Kindly, once, for
No. This counsel for the petitioner has concluded his argument. Full stop. This court, counsel for the respondent has argued the matter at length, but this court find that the respondents less plaintiff has admitted with regard to sale deed number 5294 of 1974, 5295 of 1974, 9887 of 2015, 8358 of 2015, and 9889 of 2015. Full stop. In view of the but the deeds are not on record. In view of the above, the full stop. The respondent plaintiff is directed to file supplementary affidavit disclosing the deed which the plaintiff / respondent herein has mentioned in paragraph 4 and paragraph 5, and also to give the details of the total property of the entire property and the property sold by way of the others deed and the remaining portion if any. Let the supplementary affidavit be filed by 18 after serving the copy to the learned counsel for the petitioner / defendant. List the matter on 19.
19. One more thing, my lord, I would point out, my lord, on the last petition yesterday, my lord, the name of the petitioner advocate who was appearing for the petitioner has been recorded wrongly.
Whatever your advocate on record has given, that has been, what is the name? Record and counsel for the petition submit that in the order dated 13th May 2026, the name of the advocate for the petitioner is recorded as Abhilash Mittal instead of Iftikhar Munshi. Iftikhar Munshi. And Abhilash Mittal, you. Full list.
For the opposite party, I am
Full list. The learned counsel appearing for the opposite party submitted. Abhilash Mittal is appearing for the respondent opposite party. Opposite party / plaintiff. In view of the above, in the order dated 13th May 2026, the name of the advocate appearing for the petition, the name of the advocate appearing for the petition shall be read as Iftikhar Munshi, and the name of the opposite party / plaintiff shall be read as Abhilash Mittal.
also grateful.
Kids. Yes. Item number
6.
Item 6. Yes.
The accused person has been acquitted, my lord. Charge was, my lord, under section 150 of.
You are the de facto complainant.
Yes, my lord.
You are the complainant. Complainant victim.
My lord, I have prepared this appeal, my lord, against the accuser of the accused.
Where is the judgment?
Page 9 of my petition, my lord.
This is CRA.
Yes,
Where is the special due?
sir.
Appeal against acquittal. Where is the special due?
Especially there is only one file.
Then
It will be given file, especially the application.
the petitioner has filed the present appeal against the acquittal, against the judgment of acquittal passed by the learned additional chief judicial magistrate Dinhata Kuch Bihar in case.
May I differ one judgment of honorable Supreme Court, my lord, where my lord specially it is not required when the victim is a victim, my lord. In case of victim, the appeal will be under 370.
Yes.
Provision. It's not 378. Therefore, my lord, now he can file, my lord, appeal substantive.
Correct, that's why, because you are the complainant
Right,
also.
you know, but he wrongly mentioned that he's a de facto.
De facto.
No, victim complainant, victim complainant, so he can file.
Give the judgment.
Paragraph 9. Paragraph 9.
You are the victim also.
Yes, sir, I am the victim complainant.
But under what section you have prepared an appeal?
Under section 430. But that is corresponding to 372. It's a BLS is
400.
provision.
Already noted. How you can say you are the victim? You sir.
But I have lost the complaint. It's not beautiful.
See, lodge a complaint is the complainant. Victim is whether you have injured.
Yes, my lord, I have.
What is the injury?
I have suffered a loss of my lord, rupees 9,80,000 rupees, my lord.
Yes, Mr. Bhattacharya.
Loss will include pecuniary loss from there has to be an appointment on that.
Correct. Where is our awareness?
Express amendment, I understand it's not.
There is no.
But from para 3, he has mentioned the facts for what from your last get for the checks to be or not so. The victim checks, yes, financial. That's because I have not mentioned the.
Please see when before drafting consult. Okay, you I appreciate you had a judgment, but before consulting, consult the other seniors because you are the beginners. And the appellant, the appellant has filed the present appeal against the judgment of acquittal passed by the London Additional Chief Judicial Magistrate Dinahata Kuchbihar in case number C-106 of 2020, dated 12th of February 2026, 12th of February 2026, wherein the learned magistrate has acquitted the accused persons as per section, acquitted the full story. Counsel for the petitioner, appellant submitted. The appellant was the complainant of the victim.
Sorry, pardon me. This appeal, if he wishes to invoke substantive appeal, they will be for the sessions court. Because the order
As
of
per the
the
judgment, as per the Madras High Court.
In case he wants to come through 378, then he has to file a special leave and then only. So either he has to convert it to an appeal under 378 and then he has to seek a special leave. So appeal will not be ministerial lordship. Registered order. Magisterial order appeal will lie before the court what appeal ordinarily lies. That's the court of session.
But the complaint case.
But here also is like complaint case. But he has two appeals. One is to file a substantive appeal.
If the victim.
If the victim, then it will be before the London session.
Okay.
He intends to do so. Well, not this is choice of. But if he directly wants to come to your lordship, that is also permissible. Your lordship is right. But then he has to seek for a
Seek
special.
permission.
I think better he can seek special
The-
discretion. Even to pay for an
The judgment of the Madras High Court also.
No, but that's the original. Your lordship is right. That's the original.
Madras High Court. What you want? You do one thing. Special, if you want to file as a appeal, as a simple complainant, then this leave is required. If you want that it is to be treated as a victim's appeal, then go to the sessions. Charge is yours. You want to withdraw, you withdraw, then you go.
169
কি বলছি against the sensations of judgment passed by the London ACT. Full story. Acquitted the accused, acquitted the accused person. Full story. London Council for the appellant praised for leave to file a special leave to prefer the appeal, to prefer the instant appeal. Accordingly, full stop. Leave is granted to the appellant to file a special leave for admission of the present appeal filed by the petitioner. Let the special leave be filed by. Now, when you will file? Within 2 days? That's all. क्या बोला? How soon you will file this special leave? By 19th. List the matter on 20th April. The counsel for the petition submits it. Counsel for the appellant submits it. The appellant has inadvertently mentioned section 413 of the BNSS instead of section
74 of that is 419
clause 4. Instead of section 419 within bracket 4 of the BNSS. The petitioner, the appellant is granted leave to correct the section in the cause title of the present appeal in course of the day. Next. 8. Not today. नहीं कोई 8 है. You are for the? Who is for the appellant? Pasu. Next. 9.
This is my application. Lord, am I audible?
Yes.
This is my application, Lord. There's an interim order, my lord. There are 3 FIRs by my wife. Each and every year, 1 FIR by suppressing the previous. My lord, first one is my lord, page 11, my lord. That is in Siliguri. That is case number 469 by 23, that is 22/9/23. Next, my lord, page 15. That is in Balurghat. PS case, women PS case number 76 by 24. 18/9/24, suppressing the previous FIR on the same fact. Next, we got the impugned FIR, which I am sought for quashing, seeking for quashing. That is one of the Bagdogra Police Station 212 of 2025, 21/6/25. My lord, this is the position, my lord. I pray for quashing in the last one, my lord. So there is an interim order. My lord, kindly fix the date, my lord, for the hearing, my lord.
You are enjoying the interim order.
I am enjoying the
You are
interim
already
order, my
enjoying
lord. But let it be a date be fixed, my lord, so that the matter can be concluded, my lord. Because it's a
I don't know. At this stage, it is not possible for this court to fix the date of when the state advocates will be appointed. We don't know.
We have completed the service to the state by law.
But to whom you have served?
Also on the de facto complainant as well as also on the state.
State through?
No, we have served the service to the de facto complainant.
Anybody is appearing for the state for the de facto complainant? Affidavit of service filed by the petitioner be kept with the record. It is found that the service has been affected upon the de facto complainant, but none appears on behalf of the de facto complainant. Full stop. And due to some change of circumstances, then appears on behalf of the state. According case is adjourned. Let the matter appear before the next.
One indulgence, my lord. I'm for the state actually. Today morning, I had a call from the judicial secretary who is in charge of the legal remembrance. He said case should not be unrepresented, my lord. We are praying for time, my lord. Only for that reason.
Then, my lord, fixed date, I will serve a copy to my learned friend. I will serve a copy to my learned friend.
So you are appearing for the state?
My lord, I am appearing. I have been instructed to appear. I am helpless, my lord. I have instructed by the judicial secretary.
None appears on behalf of the private respondent, de facto complainant. Full stop. Mr. Nila Chakwati, advocate appearing for the state submits that he has instructions to appear in the matter on behalf of the state. According the petition as APP in charge. Full stop. The petition is acted to serve the copy of the petition along with the documents to Mr. Chakwati in course of the day. Let the matter appear on 20th.
28.
Next.
22-0.
Next.
In item number 10.
Not today.
11.
Not today.
12.
Yes.
I'm saying for on behalf of me.
Who is for the state? You are appearing for whom?
The opposite party, victim.
But where is the state?
My lord, the IO is present. My lord, the IO is present with the original CD there, my lord. He is physically there.
Who is IO? What is their application, sir?
Against me, your section 6 will not come into.
What is your application? Yes. When the FIR was chalked out?
2019.
2019. What is the stage of the case?
SR and appearance.
Lordship, warrant is there against.
2019 charge sheet. Who is the IO? You are appearing. Come here. When the case was registered?
Case for
10/3/2019.
How many accused persons? How many accused persons in the case?
একজন
একজনে?
নাম এফআর নেমে একজন ছিল।
So investigation completed? How many accused persons have been arrested?
1 person.
Only one accused person. Charge sheet against how many accused persons? 5. So how many accused persons have been arrested?
একজন।
একজনে? What about the 4 persons?
abscond দেখে চার্জশিট দেওয়া
Huh?
লোকেশন টেস্ট করা যায় নাই এবং
Have you received the this anticipatory bail application? Have you received the anticipatory bail application?
Anticipated bill copy পেয়েছো?
ঠিক আছে? You got it? Have you searched this address?
Lordship,
Have you searched this address of the
Eh.
accused person?
address এ গেছিলেন accused person এর?
হ্যাঁ গেছিলাম
So he's not in the address. You're not in the address. How is the anticipatory bail? 2019, 2025, you are absconding. Huh?
What has happened?
Huh?
Just see the formal FIR.
Huh? I am asking one thing. 2019 case was registered. Now we are in 2025. When the charge sheet is filed,
Still I have.
চার্জশিট কবে ফাইল করবে?
when the charge sheet is filed, Mr. Chakravarti, once you are appearing, why you are not coming to the
My
court,
lord,
sir?
can it be fixed tomorrow? I'll be physically be present, my lord.
That is the problem with all of you. Once you got the
My lord,
instruction and you know that this court has issued the notice to the all officer, your officer in charge is not able to speak before the court.
My lord, one day accommodation, my lord, tomorrow.
Once you
my
had the
lord.
instruction, why you are not appearing before the court?
My lord, today morning I got the instruction, my lord.
So
At
might
the
be-
time, my lord.
So you are appearing on through video, my name be recorded, but you are not appearing.
My lord, tomorrow, my lord, at any cost I'll be there, my lord.
See, in 2019 charge sheet file, your police is not able to, and anticipatory bail application is pending, or your officer is not able to trace out the accused persons.
My lord,
This is the way you are conducting the investigation.
স্যার এখান থেকে ট্রান্সফার হয়ে মালদাতে আসছে চার্জশিট দেওয়ার পরে ট্রান্সফার হয়ে গেছে
my lord, will
So how
retain
you
the
came
CD,
here?
my lord. Tomorrow at 10:30 I'll be there, my lord, with the CD, my lord. Definitely.
You
Only
came
one
from
day
Malda.
accommodation.
Why?
আমরা ভূতনি পিএস
He has
Cannot
been posted now at Malda.
This is the case of the Pradhan Nagar. Who is the officer in charge of Pradhan Nagar?
Inspector in charge is there.
Yes, why you not come?
প্রেয়ার দিয়েছে
কি প্রেয়ার দিচ্ছে?
আইসি সাহেব কেন আসেননি প্রধাননগরে কি বলেছেন?
আমাকেই পাঠিয়েছে
You came from Malda. Wow. See, Mr. Nirad, tomorrow, then you will a tough time to you tomorrow.
My lord, I'll
If
come.
your commissioner has brought the officer from Malda, but your officer in charge is not able to come before this court.
My lord, tomorrow he will be there, my lord. Tomorrow he will be there. I'll tell him to be present tomorrow, my lord.
As per the notice issued by this court and as per the order passed by this court dated 11th May 2025, the investigating officer is present with the SEDI, but is not able to appear before this court. Full list of Leonard, Mr. Neelaj Chakravarti, Leonard, PP in charge, APP in charge, or PP in charge? APP in charge,
my lord.
press, APP in charge, press for time, according case adjourned, let the matter appear tomorrow.
Grateful, my lord.
Next. 12. Twelve is appearing. 12, who is for the petitioner? Have you served the notice? Yes, you are appearing. What is the case?
It is the case of anticipatory bail. We
Ah.
are appealing for anticipatory bail. The object today also we are paying for time. For the further process, we are paying for time because when an advocate minister, Javita Mishra is out of station and
Ah.
on the.
Why you not mentioned on that day that the officer has come from other outside? In your presence, the court has passed an order. And you know that today the officer in charge will be present before this court. Where is the notice to the victim? Where is the notice to the victim?
Instruction was given.
Huh? You have corrected the name, you have not sent the notice.
For our notice, which was served with recent still in transit, our.
Petitioner is directed to serve the notice upon the victim through the officer in charge. Bakshi her PS. Where is the notice served to the officer in charge? Where is the communication?
It was done.
Huh?
It was done orally.
Notice, how the notice will orally? You have to serve the application along with the forwarding letter to the officer in charge. It is going on. Officer has come, who will pay the cost? It's difficult, madam. Officer in charge is present. Officer in charge, Bakshihar police station is present with the CD, but the learned counsel for the petitioner has not served the notice upon the victim through the officer in charge of Bakshihar police station. Accordingly, case adjourned, the petitioner is directed to immediately take the step for service of notice upon the victim through the Bakshihar officer in charge to Bakshihar police station to the victim. In course of today itself, let the matter appear on 20th. Serve the notice to the victim. Give the notice to herein now. 14. Who is appearing? Yes.
But
Who is for the? Who is appearing for the officer in charge? Sitai police station.
Sir.
Yes.
I have, sir.
Yes. What is the stage of the investigation? Where is your CD?
CD legal.
What do you want to say about this matter?
Sir, regarding bail, sir. Bail নাহলে স্যার খুব ভালো হয় স্যার। জিএফসির এগেইনস্টে এখানে প্রেয়ার হয়েছে স্যার অর্ডার কোর্টে গেছে। সেই স্যার খুব সুবিধা ছিল না স্যার। এলাকায় তার নোটারিয়াস একটা রেকর্ড আছে স্যার।
Notorious. How many cases?
Already sir, one case and another case.
Have you mentioned in the CD?
No sir.
So you have not taken the details of the cases. You not mentioned in the CD.
Sir, পরে আমরা জানতে পেরেছি।
Why you not arrested? Why you not arrested?
পাইনি স্যার এখন বলতে পারি। ইলেকশন রিলেটেড ছিল না স্যার, আউট অফ স্টেশন ছিল স্যার।
Who?
যিনি স্যার পিটিশন করে অর্ডার করে কাছে যিনি বেল ক্লিয়ার করছেন।
He has not cast vote. He has not casted the vote on 29.
ভোট দিয়েছিল? না ভোট দেয়নি স্যার।
দেয়নি?
না।
Sure. I will call report.
Sure sir.
Yes, what is the matter?
The case was initiated on 4th of March 2026. Now kindly see the sections 25(1)(a) and 27 of Arms Act. But kindly see page 11 of my application. The complaint. Complaint come forwarding report. Kindly see the first paragraph. The on first day, Koruna Bormon, who was produced before the trial court with seizure.
One improvised iron made, one shooter firearm.
Yes.
And one live ammunition. Do you have lodged the counter complaint? But we success to catch the pillion rider who jumped from the bike, got injured.
More surprisingly, my lord, kindly see, police did not identify the registration number of the motorcycle, and the arrested person named this petitioner, my lord.
Yes.
This is the allegation, my lord. And as per section, my lord, maximum punishment is my lord, up to 7 years, not less than 3 years, my lord. I am seeking anticipatory bail. I will assist the investigation.
Have you issued notice?
No, sir.
Why? You're not issued notice to the accused.
No, sir.
Why?
এত ব্যস্ত ছিলাম স্যার অ্যাকশন রিটের মধ্যে স্যার সময় হয়ে গেছে স্যার কেস ইজ অফ 4th of March.
Where is other? He has gone to the Karuna, he has got the bail.
Sir, already we get bail.
Huh?
Already sir bail আছে স্যার bail পেয়েছে স্যার
He peche.
Sir.
When?
18 দিন পর after 2 months.
इसमें देखो किस बोलो show from which order?
দেখি দিন কবে অর্ডারটা আছে না সিলিটা
না যেহেতু হাজিরা দিতে আছে সেহেতু তখন আমি
अपना सीडी अपना सीडी एंट्री करी ना बेल पेगा छे
এটা রেকর্ড এখন তো সাম পেয়ে দেখছেন বিল পিকচার টোটাল করতে আমরা তার কোনো রিপোর্ট পাইনি স্যার
কি
যে বিল হয়েছে ও আছে হাজিরা দিতে এই হিসাবে বলতে পারছি স্যার যে ও বিলে আছে
The petitioner has filed the present application under section 482 of the BNS 2023, praying for grant of anticipatory bail in connection with Sitai Police Station, case number 30 of 2026, dated 4th of March 2026, under section 25(1) within bracket small a oblique 27 of Arms Act police. The counsel for the petitioner submitted the police has registered the case on the basis of the written complaint of PSI Tapas Kumar Rai, Sitai Police Station, Kujbihar, on the allegation that on the information received by the police, the police have apprehended one person. The police have apprehended one accused, namely Karuna Burman, who was the pillion rider of the motorcycle. And on interrogation, and when the said accused was, when Mr. Karuna Burman was apprehended, the police has recovered one improvised iron-made one-shooter firearm and one live ammunition. And on interrogation, the arrested accused has informed to the police that the said arms have been provided by the petitioner herein, who was the rider of the motorcycle and fled away when the police tried to apprehend the said accused person, the petitioner. Police. Then a counsel for the petitioner submit that in the complaint there is no mentioning with regard to the motorcycle number. The police has only registered the case only on the basis of the statement of the co-accused. He further submit that the co-accused who have been arrested, from whom the the arms have been seized, has already been released on bail. Then in terms of the order passed by this court, 12th May 2026, the IO is present with the case diary, and he raised the objection for grant of bail to the petitioner and submit that the petitioner is a notorious criminal having several cases registered against the petitioner, and he is the main accused who has supplied the arms to the co-accused who was arrested who was arrested on apprehending the same on the date of alleged incident. Police heard the land counsel for the respective parties peruse the materials on record. This court find that the case has been registered on 4th of March 2026. 26. The accused, the main accused in whose possession the arms have been seized has already been released on bail by the Leonard trial. The police, even the investigating officer, has not issued any notice under section 41 of the code. 41, what is the new section 41?
35(3) of the
Under
BNS.
section 35 within bracket 3 of the BNS. Though the punishment is 35 of the BNS. Police. At the police, considering the above, police of this court find that the accused from whom the arms have been seized, he has already been released he has been released on bail by the Leonard trial court, and as such there is no purpose to bail, and as such this court find that, and as such the petitioner has made out a case for grant of anticipatory bail. Accordingly, the CRM is allowed, if the petitioner is arrested, the investigating officer shall release the petitioner by release on bail by furnishing surety of rupees, by furnishing two sureties of rupees 10,000 each, and if the petitioner shall comply with the petitioner shall appear before the investigating officer once in a week and shall not leave the jurisdiction police station without the leave of the trial court. CRM is disposed. CD is returned to the investigating officer. Next.
Lord, I have for the petition, my lord. Allegation under section 85, 83, 305 of the BNS Act, my lord, corresponding to 498A, 304B, and 34 of the Indian Penal Code, my lord.
Yes.
The petition victim
When the case was registered, February, why you not arrested?
One person, sir.
One person.
the principal accused already
Who is he?
arrested.
Husband?
Husband, sir.
Yes.
I'm the
What
father-in-law,
is the stage
mother-in-law.
of the
my lord.
investigation? What is the stage of investigation?
Sir, no custody.
No custody. হ্যাঁ
আর 7 দিন টাইম আছে আমি দিব কাল পরশু
হ্যাঁ
এখনো 7 দিন টাইম আছে আমি কাল পরশু দিব স্যার
investigation completed, so why you are not arrested?
স্যার আমি রেড করেছিলাম বলে অ্যাবসলিং আছে শ্বশুর মশাই এবং শাশুড়ি আর খবর পেয়েছিলাম একবার ভোটের সময় বাড়িতে আসছে কিন্তু ওই সময় শ্বশুর যে আছে তিনি হার্ট অ্যাটাক স্ট্রোক করেছে স্যার এটা খবর পেয়েছিলাম
Have you issued notice 35? No.
So committed suicide, my lord.
Who committed suicide?
Victim committed suicide, my lord.
So when you commit suicide?
Victim committed suicide.
When?
Lord, the committed suicide, my lord, according to my lord, 13/5/2025. No, my lord, bring apology, my lord. 19/2/2026, my lord. 19th February.
That's why the FIR.
Yes, my lord.
Then
Yes, my lord.
so you're not appearing with the investigating officer. You're not cooperating with the investigating.
My lord, not my lord. If the below 7 years, then my lord, 35 notice should be given, my lord.
Why
Otherwise,
below 7 years? What is the section against you?
my lord, inter allegation 498A, 304B, and 30.
Then for 304B, what is the punishment? What is the punishment?
Lord, I have to. A notice has not been served, my lord. I have to check, my lord.
Which notice is not served?
Bring apology, my lord.
What is the evidence you have collected? What evidence you have collected against the accused person?
স্যার উইটনেস আছে স্যার উইটনেস
হ্যাঁ
ওরা বলেছে স্যার বাড়ি মানে বিয়ের পরে থেকে বাড়িতে অশান্তি হচ্ছে স্যার
হ্যাঁ
আর কারণ নিয়ে চাপিত স্যার হাজবেন্ড শ্বশুর শাশুড়ির সঙ্গে খুব ঝামেলা হতো
Yes, he has committed suicide due to the torture.
My lord, this is the allegation, my lord, the general omnibus allegation, my lord. There is no specific allegation
Within
against
9
him.
months of the marriage.
My lord, general allegation, my lord, parents, their parents, my lord, they are seniors or aged person. There no purpose will be similar. According to my the charge sheet will be filed, my lord. My lord, I will cooperate the investigation, my lord.
What you cooperate the investigation?
No, nothing, my lord. No purpose will be served, keeping in custody, my lord. Charge sheet, investigation.
What the
all-
postmortem report says?
Show us, show us.
Only one accused person?
3 accused persons.
How many persons have been arrested?
1 person.
Who is he?
Husband, sir.
Principal
Husband, husband arrested. And who is the petitioner here?
শ্বশুর মশাই এবং শাশুড়ি।
Husband got bail?
No, my lord.
No. What is the allegation? Where is the evidence against him? Where is the 161 against him? Where is the evidence of this accused person, this person's 161 statement?
কোন কাগজে লেখা আছে? এটা যশ সাহেবকে দিন, যশ সাহেবকে দিন, আমাকে দিন না।
Who has given 164 statement?
স্যার আছে স্যার, পরে আছে।
Who is the witness?
ডিসিজ যে মারা গেছে তার মা বাবা।
Mar Baba.
স্যার।
They are the interest witnesses, my lord. There are no, if
The
kindly similar, if there are private
Petitioner has
independent
filed the
witnesses, they are not.
application for grant of anticipatory bail under section 482 of the Bharatiya Nagarika Surakha Sanhita. क्या बोला? In connection with Gosadhanga Police Station case number 86 of 2026 dated 20th February 2026 under section 85/80/3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023 corresponding 2023. The learned counsel for the petition submit that the deceased has committed suicide by hanging and the petitioners are not involved in the present case. The further submit that the husband has already been arrested and in custody. So they submit that the petitions have no role to play in the incident case, but there is every apprehension that the police will arrest these petitioners who are the mother-in-law and father-in-law. Father-in-law
Father-in-law and mother-in-law, my lord.
Mother-in-law and father-in-law of the deceased. And then the IU is present with the CD. IU is present with the CD wherein it reveals that investigation, most of the investigation has been completed and the husband has already been arrested. He has got bail. Husband has got bail. No. Husband has already been arrested and is in judicial custody. He is in judicial custody. Considering this, find that then the custodial interrogation of the present petitions are not required. Accordingly, if the petitions are arrested, they shall be released on bail of rupees 10,000 with one security. If when the petitions are directed to appear before the investigating officer twice in a week and shall not leave the jurisdiction police station without the leave of the trial court until further order by the trial court. CRM A 2026. Granted, they may be released on bail and they will appear before the Thana twice in a week and they will not leave the jurisdiction of the police station. I will come.
Please.
My lord, I am for the petition.
Yes.
My lord, kindly come to my lord, page 9, my lord, that is the written FIR. My lord, the gist of the, my lord, the prosecution case is that, my lord, one Hemonto Bormon, my lord, he was apprehended along with his e-rickshaw. He was the rickshaw puller, my lord, by the BSF personnel. And my lord, after my lord conducting the search, my lord, a huge quantity of contraband article has been, my lord, recovered.
Correct.
My lord, he was taken into custody. A confessional statement, my lord, was my lord, extracted from that Hemonto Bormon.
Correct.
From his confessional statement, my lord, my name has been, my lord, arrayed in the FIR.
Correct.
My lord, the entire contraband article has been, my lord, recovered from that Hemonto Bormon. Now, my lord, so far, my lord, the my lord, confessional statement under section 67 is concerned, my lord, it is completely my lord, inadmissible. My lord, kindly have a look on page 9, my lord.
Yes. Then
My lord, even my lord, in the my lord, the written complaint, there is no whisper with regard to my name. Nothing, my lord. Whatever they have, my lord, conducted the search, my lord, the procedure of search, and my lord, the how the contraband article has been recovered, my lord, the entire my lord incident has been my lord narrated in the FIR. My lord, my name, my lord, so far my name is concerned, my lord, it has been my lord arrayed, my lord, from the confessional statement. My lord, and my lord, by virtue of my lord, the
why anticipatory bail?
my lord, nothing has been recovered from my possession, my lord.
NDPS case, anticipatory bail, rare.
My lord, what has been recovered, my lord, 37 is, my lord.
Go and argue before the London trial court when he was arrested. Then you mention.
My lord, nothing has been recovered, my lord, from my possession. Who has been, my lord, found, my lord, rare?
How the anticipatory bail in the NDPS case, rarely the court find that no case is made out.
My lord, kindly consider, my lord, my source of implication. What is the source of my implication, my lord?
Yes.
My lord, one person has been, my lord, caught red-handed with the contraband article.
Correct.
My lord, my lord, the entire contraband article has been recovered from his possession,
So
my
where
lord.
from you got that your name is there?
My lord, page 9, my lord. आगे আছে এবারে তো আমার মনে নেই কনফিউশন আমি তো হেমন্তরই নাম আছে হেমন্তরই নাম আছে
Where from you got your name?
My lord, take a second one. Yes, my lord. Page 9, my lord, paragraph 12. That is in the, my lord, the box, my lord.
Page 9.
Page 9.
Name of the person disclosed by the
apprehended person.
Yes.
That has also been, my lord, specifically indicated, my lord.
Majumdar Mia.
Mujumdar Mia, my lord.
Yes. Yes. What is the stage of investigation?
Charge sheet already submitted.
Charge sheet submitted. What about this accused person, this petitioner?
Sir, it was previous in 94/2025. Under section NDPS Act also have registered against him.
Prepared report.
Last paragraph, sir.
Could not be found.
The last paragraph.
Last paragraph. CD. What is the allegation against this petitioner? What is the allegation? Only has given the name. What is the allegation?
So this complaint mentioned that the arrested person has.
He has only given the name. What he has stated? The petitioner has filed the present application being CRM number and the present application under section 482 of the Bharatiya Nagrik Suraksha Samhita 2023, praying for grant of anticipatory bail in connection with Setai Police Session case number 262 of 2025 dated 15/11/2025 under section 21 within bracket C within /29 of NDPS Act. Counsel for the petition submit that the police has arrested the accused, namely, what is the name of the prime?
Hemanto Burman.
Hemanto Burman, and alleged to have been seized 75 bottles within bracket 100 ml each of Escuf cough syrup. Full stop. Counsel for the petition submitted that only the name of the petitioner is included in the complaint on the basis of the statement made by the co-accused. He submitted that nothing was seized from the petitioner and petitioner is not at all involved in the matter. And as such, the petitioner has filed the present application for grant of anticipation. The investigating officer is present and produced the CD and submitted the report. From the report, it is found that the investigators and charge sheet submitted. As counsel and the investigating officer submitted, the investigation has been completed and charge sheet has been filed. Charge sheet has been filed against this petitioner as well as the main accused Hemanto Burman. Police. The investigating officer submitted the accused could not be arrested because he is absconding since the date of initiation of the case. The reports reveals that the report submitted by the investigating officer reveals that the investigating officer could not find any track with regard to the bank account to show that there is any transaction between the main accused and the present petitioner. The investigating officer further submitted the report that due to an inability of the phone number of the petitioner, the call details of the petitioner could not be traced out. He submitted that he pressed for rejection of the application. for grant of anticipatory bail. At the landed counsel for the petitioner and the investigating officer peruse the application and the case diary and the report submitted by the petitioner. It is for grant of anticipatory bail under the NDPS case, it is very for grant of anticipatory bail under the NDPS Act, and the court is very slow because section 37 provides no bail to be granted if the narcotics seized from the accused is commercial in nature. In the present case, this court find that all the seizures has been made from the prime accused, and the investigation has been completed. Police has submitted the charge sheet. The investigating officer in his report has categorically stated that no report could be collected to show that there is any transaction between the main accused and the petitioner. Considering the above, this court find and considering the special circumstances, this court find that there is no such allegation against the petitioner that anything has been recovered from the petitioner or there is any connivance with the prime accused and the petitioner herein. Police. It is also find that the investigating officer has not brought anything on record that there is any conversation between the petitioner and the co-accused. Considering the specific circumstances, the bail within the anticipated bail application is allowed. The petitioner is, if the petitioner is arrested, it shall be released on bail of rupees 10,000 and 20,000 with true surety. Police term, the petitioner shall appear before the and shall not leave the jurisdiction police station without the leave of the trial court, and it shall appear before the trial court on each and every date of hearing. CRM is disposed of, CDB returned to the investigating officer. इसको वापस करो. Next.
17.
ये तो दे दें. चार है पहले दो ना. Yes.
For the defective update.
Yes.
What
What is the case?
Section 351, 69 and 77 of the first year. This case, what had happened was the de facto complainant, she had a dispute with her husband. On 15th of December 2025, she voluntarily left her matrimonial house, and thereafter the allegation is that the petitioner took the de facto complainant to his house, and thereafter the petitioner, on promise of getting married with her, committed rape of her. And this is all the crux of the allegation is, and the incident is taken place in December 2025, and the FIR has been launched in the month of February. After 3
The investigation officer is present today. Have you forwarded the order copy?
Served a notice to the.
No, this order was forwarded. This order has not been forwarded. You have not gone through the order. Communicate this order. In spite of the order, and the petitioner has not communicated the order dated 12th of May 2026, wherein this court has directed the officer in charge of the Rajganj police station to produce the case diary. Police stop. The petitioner is directed to communicate the order dated 12th May 2026 to the investigating and to officer in charge Rajganj police station, and the officer in charge is directed to produce the case diary on the next date fixed. Is the matter on 20th. Yes, next. Yes. What is the case? 300? 4B. Yes, what is the stage of investigation?
Principally accused,
Huh?
principally accused arrested
Huh.
and co-accused absconding.
Absconding. So where is the CD? Why you are not arrested? Mother-in-law. So what is the role? What is the role of the accused person, the petitioners? Huh? অত্যাচার করে দিচ্ছে। How he died? How she died?
Suicide, committed suicide.
By hanging.
My lord,
What is the stage of investigation?
principal accused is JC and co-accused are absconding.
Whether their detention is required? Their detention is required. What do you want for the investigation for these petitioners? What investigation is required for appearance of the petition before you? What evidence is required to be collected?
164 sir, done, sir.
164?
Done.
Done. Postmortem report
Postmortem done, sir.
conducted. You received. So whether their detention is required? Why you not arrested so many days when the FIR was chalked out? 9th February. Huh? So why you not arrested?
Absconding, sir.
Absconding. What the police is doing? The petitioner has filed the present application under section 482 of the BNSS, praying for grant of anticipatory bail in connection of Jalpaiguri Police Station, case number 44 of 2026, dated 9th February 2026, under section 85/80/ within bracket 2 within /3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023. Counsel for the petition submit that the petitioners are the only one petitioner. Who is he? Husband is in custody. The petitioner is the mother-in-law of the deceased. The son of the husband of the deceased are already been arrested and is in custody. He is in custody. Full stop. He submitted the petitioner has no way connected with respect of the said crimes. He further submit that the deceased has committed suicide of own and the petitioner has no way of her own, but only to but the relative of the deceased have been falsely implicated the petitioner in the present case. The IO is present with the case diary. He submit that the husband is already been arrested and is in custody. He further submitted the petition. He could not arrest the petitioner. As petition is absconding since the registration of the FIR. He further submitted what is the stage of the investigation? Completed?
Sir.
Huh?
Sir.
Charge sheet filed?
No.
He further submits that most part of the investigation is completed and already received the postmortem report. Consider the submission made by the counsel for the petitioner. Peruse this case diary. This court find that the custodial detention of the petitioner is not required. The husband is already in custody and most part of the investigation has been completed. In the above, CRM AR number 272 of 2026 is allowed. In the event of error, the petition shall be released with the bond of ₹10,000 with security. Then the petition is directed to appear before and is directed to appear before the London Trial Court on each and every date of hearing, and he shall not leave the jurisdiction police station without the prior permission of the trial court. Next. 19. Yes.
Elder brother-in-law.
What is the case? Who is he?
Elder brother-in-law.
Elder brother-in-law. Yes. What is the investigation? What is the stage of investigation? শেষ হয়ে গেছে?
3% arrested, sir. 1%
3% arrested. Husband?
mother-in-law, father-in-law.
They are arrested. He is brother-in-law. One of the brother-in-law. So why you are not to surrender?
I have no role, kind of brother-in-law.
What about that they have been granted bail or they are in custody? এরকম আয়ু আপনার other three accused persons have been granted bail or in custody? How many persons have been arrested?
3%.
They have been they are in custody or granted bail? You don't know, are you?
Instruction granted.
Huh?
Instruction granted.
Instruction granted bail. When they have been arrested? You don't know whether they have been arrested, they have been granted bail or not? Huh? Huh? हिंदी बोलते इंग्लिश बोलते करते उसे पूछा बंगाली में बाकी लोग का बेल हुआ कि नहीं हुआ?
যে কজন অ্যারেস্ট হয়েছে তাদের বেল হয়েছে?
হ্যাঁ
শুনতে পাচ্ছি।
সামনে কি বলবো?
তিনজনের হয়েছে মনে আছে? তিনজনের হয়েছে, একজন অ্যাবসেন্ট।
হয়ে গেছে কি বেল হয়ে গেছে?
তিনজন arrested, sir.
Arrested, whether they have been granted bail or they are in custody.
ওরা কি এখনো ধরে আছে না ওদের বেল হয়েছে? বেল হয়েছে।
So क्या मान? Where is writing? Where is the report? They have been granted bail. Have you mentioned? CD तो इंग्लिश में लिखते उसको इंग्लिश नहीं आता. CD तो इंग्लिश में लिखा हुआ है. ये दो बोलो. You also don't know where is the bail order. You're not appearing with your trial court. Record on. The petitioner has filed the present application praying for anticipatory bail in connection with Matha Bhanga Police Station case number 476 of 2025 dated 20th June 2026 under section 85 of the 80 of the Bharatiya Nyaya Sanhita 2023 pending before the London Additional Chief Judicial Magistrate Matha Bhanga. Counsel for the petitioner submit that the petitioner is the brother-in-law of the deceased. Brother-in-law of the deceased. He submit that the husband, mother-in-law, and
Father-in-law and mother-in-law.
And father-in-law and mother-in-law already been arrested by the police. He submitted the petition is no way connected in the present case, only on the basis of the alleged complaint of the relative of the deceased. The police has initiated the case against the petitioner. Also, the investigating officer is present along with the CD. This court finds that the investigation has been completed and charge sheet has been filed. Accordingly, this court is of the view that the custodial interrogation of the petitioner is not required. Full stop. In the event of police to be entered, the criminal application CRN number census and disposed of by naked and full stop. In the event of arrest, the petitioner shall be released on bail by if bond of rupees 20,000 with one surety. Full stop. The petitioner shall appear before the trial court on each and every date of hearing without fail. CRM disposed of. He shall not. No, it is not. You file the charge sheet, it is recorded. You are not telling that now charge sheet is filed. Type of the investigation was there. Read the last page. Yes. De facto?
De facto service is
Not completed. So through the police, you are appearing for your IO or officer in charge?
IO as well as officer in charge.
So you served the notice to the victim also?
I did give a notice.
You did not get any notice? The investigating officer is present. Counsel for the petition submitted the notice upon the victim could not be served. Accordingly, petition is directed to serve the notice upon the victim to the officer in charge of the Nahata Women Police Station. The officer in charge of Pinata is directed to submit the report on the next date. Fix the matter on 20th.
21.
Appearance, sir?
As per the prayer made by the counsel for the petitioner, let the matter appear on 21st May 2026. Next. 22. Yes.
In this case, Order. 9, 10 and 11 of the violation of child marriage act, present in the seats of the court.
Who are you?
Petitioners are the parents of the principal.
Parents of the principal.
Cases of NDPS Act, my lord. But nothing has been recovered from the possession of the petitioner. His name has been transferred from the mouth of the arrested accused person, from whom, my lord, 33 bottles of cough syrup has been recovered. My lord. Charge sheet has already been submitted. Charge sheet.
Go and surrender. The petitioner has filed an application for grant of anticipated bail under the NDPS Act. it is fine that the investigating officer,
my
investigation
name
has
has
already been completed, charge sheet has been filed. Accordingly, petition directed to surrender before the trial court.
My lord, if I go surrender, my lord.
Next.
24, I'm for the petition, my lord. The allegations are against the in-laws as well as the husband. The allegation is against under section 85, 109 and 35 of BNS. My lord, out of 5 accused persons, 4 has been enlarged on the anticipatory bail by the district and session judge.
Who are you?
I am the husband. The allegation of 498, nothing else.
Go, surrender.
My lord, kindly see the
Husband, I will not grant.
My lord, there is no injury. There is no injury, my lord. The only allegation of 498A.
No problem. Have you received the notice of 14?
No, my lord, no notice was served.
Yes, why notice not issued?
My lord, kindly
Have you issued notice under section 35? No, why? Huh? You are appearing, you are IO. You are investigating officer. আপনার investigating officer in this matter. Huh?
My lord, kindly have a look for once an P2 order dated 10/2/2026. Wherein the record, the order specifically says the injury is simple in nature.
Injury is not required under 498. Injury is not required. 498.
My lord, kindly have a look at the FIR. 3 years of relationship. Thereafter, the petitioner got married with the daughter of the de facto complainant. The allegation is that the parents of the present petitioner were not happy with the relationship. This is
the CD.
I would comply with the term and condition. Whether my custodial interrogation is required or not. I have not absconded, my lord. First, I have prepared an application before the session judge. Then I approach this honorable court. So I have not absconded till date.
What is the stage of investigation?
চারজন ঠান্ডা বেঁচে স্যার প্রিন্সিপাল বাড়তে গিয়ে হুমকি দেওয়ার চেষ্টা করছে
I will join the investigation.
Allegation is serious.
Well, the order dated 10/2/2026 specifically says the injury report is simple in nature. Another may be imposed, my lord, if required for the investigation purpose.
You filed an application before the trial court?
My
before
lord.
the anticipatory,
Before the sessions court.
What has happened?
It is at annexure P2 order dated 7/3/2026, page 11, 12 and 13. And the order granting bail to the other accused is at page 10 and 11. The FIR was lodged by the father of the wife. The statement may be look into, my lord, of the wife.
You filed an application for bail.
for anticipatory bail before this session judge, which was rejected, is at
By
page
which
12
order?
by order dated 7/3/2026,
Where is that?
page 12 and 13.
Why you are not arrested after March 2026?
বর্ডারের পাশাপাশি পাশে ফেন্সিং এর পাশে ওনার বাড়ি তো ওরা যখনই রেড করতে যায় তখন বর্ডার
The petitioner has filed the present application under section 482 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for anticipatory bail in connection with Pulibari Police Station, case number 8 of 2026, dated 22nd of January 2026, under section 85/109/3 within bracket 5 of the Bharatiya Nagrik Sanhita 2023, full stop. Counsel for the petitioner submit that the wife has made a false complaint against the petitioner and his family members. He submit that the mother, father and brother-in-law.
Yeah, my lord.
The
Yes, my
mother,
lord.
father and brother-in-law already been granted anticipatory bail by the Learned Court of Session Judge. But the Learned Session Judge has rejected the anticipatory bail of the petitioner. He submit that as per the allegation of the wife, as per the allegation in the FIR, that the petitioner has assaulted.
Complaint has been made by the father of the wife, my lord.
As per the complaint made against the he submit that as per the complaint, as per the allegation that the wife and the petitioner has assaulted the wife and the wife has sustained injury, but as per the injury report, the wife has having only the simple injury. He further submit that if this court grant bail, the petitioner will appear before the investigating officer and cooperate with the investigating officer. The Ayub is present along with the case diary. The Ayub submit that the mother, father, and brother of the petitioner were arrested and were granted bail as there was no necessity for their custodial interrogation, but the bail application of the petition was rejected, and as the interrogation of the custody interrogation of the petition is very much required. He submit that whenever the investigating officer tried to arrest the petitioner, the petitioner absconded. He is not available either in the village or in the house. Consider the submission made by the counsel from the respective parties for the materials in report. This could find that it is the specific allegation against the petitioner that the petitioner has assaulted his wife with an iron rod, causing injury, and as per the injury report, this could find that though the victim has suffered simple injury, but there was an injury on the head, on the head of the victim as well as on the neck of the victim. Considering the above, this could find that the custodial interrogation is required in the present case. Thus, this is not a fit case for grant of anticipatory bail. Currently rejected. Next. CD go up. 25.
Service is not rejected.
Let the matter appear on 21. Next.
21.
26. Yes. Why IS present? IS present? What is the case? What is the case under section? The petitioner has filed the present application under section 482 of the Bharatiya Nagrik Suraksha Sanhita, Bharat Nagrik Suraksha Sanhita 2023 for grant of anticipatory bail in connection with Jalpaiguri PS case number 290 of 2025, dated 31st of July 2025, corresponding to 2025 under section 21 within bracket C slash 25 within bracket 25 slash 29 of the NDPS Act. NDPS Act. NDPS Act. Police. This court find that the since the arrest the petitioner is absconding and the custodial interrogation is necessary. Accordingly, CRM is dismissed. Next. 27. Yes. What is the section?
490 326 468 468
এইটা রিজেক্ট করেছে
husband and wife set up a private school. They are the staff of the school. One is the principal and another is
Are you present?
yesterday, I think tomorrow will be there.
Not today. Next. 28. Why? Not today. Next. CRA. Next. 29.
ভোট চলছে ভোট চলছে কিনা আমার ভোট চলছে
29 not today. Next. 30. 30. Not today. 31.
For the complainant, file an application for cancellation of the bail.
Have you served the notice? Issue notice. Give the fine.
Petitioner accused for filing the bail application.
The petition has filed the present application for cancellation of the bail granted by this court. The petition has filed the present application for cancellation of the anticipatory bail granted by this court dated 9 November 2022 in CRM within bracket A 527 of 2022 arising out of Pradhan Nagar Police Station case number 132 of 2019 dated 10th of March 2019 under section 6 and 8 of the POCSO Act. POCSO, full stop. The petition directed to serve the notice upon the state as well as the
Notice party the no one. Name of the victim has been rejected. That is one. 32.
yes. Cancellation of anticipatory bail. So notice served. The petition directed to serve notice upon the opposite parties. List the matter before the next circuit bench. Next. 30.
35.
Till 35. All cancellation. 35 same order. Issue notice next circuit bench. Issue notice, file affidavit service. Issue notice upon the opposite parties and to file affidavit of service on the written number date. List before the next evidence. 32 to 35. 32 to 35. Next. 36.
Regarding the interim maintenance, quantum of interim maintenance and entitlement of interim maintenance.
So Your Honor, I'm appearing on behalf of the respondent. The senior counsel is currently arguing another matter in court number 7. If you could please grant a short pause.
It was specifically fixed today, Lordship, because.
Also,
Lordship.
Thank you.
next,
37.
I didn't know 37. I'm for the petitioner, my lord.
yes.
My lord, in this matter, the state was directed to file a report, but till date, no report has been filed. We haven't.
Criminal motion, what is the report? In criminal motion, who will file the report?
So, my lord, the state was directed to file a report
For?
with respect to the case. In last order, it was mentioned.
Fourth day of next available circuit bench. Nobody is appearing for the state. As none appears on behalf of the state, let the matter appear on 19. Next.
Grateful, my lord.
38.
My lord, I'm on behalf of the petitioner, my lord.
Can it be taken up tomorrow, Lordship?
Why? Appearing for the appearance of the present revision of application challenging the order granting interim maintenance.
Yes, your Lordship.
You are for the?
I am for the husband, Lordship.
You are for the petitioner?
Yes, my lord.
Petitioner
I'm
husband,
for the petition.
wife.
Yes.
OP wife.
No,
OP,
Lordship.
not wife, for the son.
Minor
Minor son represented by the wife.
On what
mother.
ground you are challenging the minor son? What is the amount?
Yes, Lordship. Lordship, the amount is 30,000. My lord, although my lord, I am paying, my lord, I want to pay. Because my lord, before that, Lordship, the marriage in the year 2015.
Correct.
Thereafter, both are doctors, Lordship.
Husband, wife, both
Initially,
doctors.
yes. Husband was posted at Boshirhat, wife was in Kathi, Mednipur. During that period, that is in the year 2018, the wife conceived and gave birth of a male child. Thereafter, both of them, my lord, transferred to Arjikar Medical College and Hospital. My lord, from Arjikar Medical College and Hospital, both of them transferred to Falakata Super Specialty Hospital. My lord, during that period, my lord, differences of opinion, my lord, cropped up between two. My lord, there was no, my lord, any kind of other bitterness. So, my lord, thereafter, the wife left voluntarily with the child on 30th September 2024. Thereafter, Lord.
Along with the child.
Along with the
What is
child.
the age of the child?
Child is now
7 years old.
my lord,
So he is with the husband. He is with the mother.
He is with
In
the
which
mother.
class is studying?
Class 2.
Yes.
They are staying at Alipurduar.
Mother and child.
Mother and child is staying at Alipurduar. Father is staying at Falakata. Now, Lordship, thereafter, a draft of mutual divorce was drafted. Mother, they both were willing for the divorce on mutual consent. Now, my lord, in the said draft, which I have annexed, some of the clauses, my lord, were not accepted by the wife regarding that child, the maintenance of the child. The husband said that he is willing to maintain his child, but he wants him once in a week or something like that. That was not accepted by the wife. Therefore, the mutual divorce, my lord, could not be materialized. My lord, surprisingly, after that, the wife filed an application under Section 498 of Indian Penal Code against the husband and all the family members of the husband, although she never resided with the other family members of the husband. My lord, I have annexed the draft copy of the 13B petition.
So that is your,
Yes.
what about the interim maintenance?
Yes. Now, Lordships, the wife had filed an application under 144 of BNSS, which is 125 of the CRPC, claiming for maintenance, saying that the husband is earning 90,000 per month he is a surgeon from the hospital, and he has some attachment with the private nursing home from where he is earning 8 lakhs per month. So therefore, she claimed for 90,000 for the child. Now, my lord, the wife is also a doctor. Lordship, I have annexed, Lordship, the affidavit of assets and liabilities of the wife, which has been, my lord, submitted before the learned court. If your lordships kindly comes to page 33.
Yes.
Lordship kindly comes to page 35. This is the assets and liabilities of the wife. That is page 35.
90,000 per month.
She is also, my lord, earning 90,000 per month.
Correct.
They are in same position, same status with the same salary, lordship. And another thing is, my lord, the details of the
Husband has filed the W or no? Is the entry maintenance?
No. Entry maintenance.
Without W, it was taken off for hearing.
Yes, your lordship. Now, lordship, another thing your lordships will find the details of the liability of the deponent. She said no. She has no liability, lordship.
Which clause? Which clause?
My lord, lordship kindly comes to H. From the bottom portion, your lordship will get details of the liability of the deponent. Your lordship has got it?
Yes, yes, yes.
No. So, my lord, this is the assets and liability filed by the wife, and lordship, my lord, pursuant to a leave granted by the earlier honorable court, my lord, I am filing the supplementary affidavit where, lordship, I have annexed the assets and liability of the husband also. Where the husband also, my lordship, will get that the monthly income of the husband, it is bit illegible. I have given the typed copy thereafter. The monthly income of the, yes, I'm coming. Yes, page number 6. Page number 6 of the supplementary affidavit, the monthly income of the husband is 95,000.
Yes.
Now, your lordships, they kindly see the impugned order. The last part of the impugned order, your lordship will find the learned court observed that the husband is earning 13,19,573 annually.
Where from you are getting?
Lordship, the last page of the certified copy of the impugned order. My lord, the little above than the ordering portion. The husband is earning annually 13,19,573. Lordship has got it.
Which page? Which paragraph?
Paragraph 7. The middle part, lordship, will come. The income tax return acknowledgement of the opposite party for the assessment year 25-26 shows a declared annual income of the thereafter 13,79,573, which means, my lord, he is earning, my lord, 95,371 per month. My lord, after this supplementary affidavit, my lord, I have received the pay slip of the husband, wherefrom your lordship will get that the net pay rupees inward 95,371 only. Lordship. Now, my lord, since my humble prayer is, I have never neglected my child. I am paying, my lord, it is up
this
to
is
the
entry maintenance.
Yes, lordship.
Correct.
My lord,
Which court is that pass? Judicial magistrate, first court.
Yes, yes,
So
your lordship.
how you come to the high court? Why you not going to the sessions judge?
My lord,
First available.
my
Sorry.
lord, revisional code.
Maybe
Lordship,
revisional
it can
code.
be,
No,
my
no.
lord.
This practice, as far as myself, this court is concerned, I am deprecating all these things, avoiding the sessions court, coming to the high court. High court is already having so much burden. You go to the sessions court, you make all. Sorry. See, this interim maintenance and all these things, either you could have been filed the application before the magistrate itself. It's a maintenance matter. You could have been filed the modification over there, or you could have been filed the revision before the session judge.
Submission is this, my lord, I am ready and willing to pay everything, my lord, I want to do for my child, but the amount should be proportionate because both of them are in, my lord, in the same status, same earning. The amount should be proportional. Lordship, there are the several judgment of the Honorable Apex Court that the proportion, my lord, would be, my lord, the amount would be as per
Yes,
the
why
proportion of
90,000, 30, what
I'm
the
replying, Lordship.
second class
So for
student
the-
will get the
so for-
30,000?
Also, I'm replying, Lordship. So for the impugned order is concerned, now this is not this revision application is not maintainable on a particular ground that he has, after in compliance with that particular direction, he has steadily making payment. Now,
That
once
is
at
different
once-
thing. I am asking one question. The 7 years child studying in class 2, you are also the doctor, the husband is also doctor, 30,000, what?
There is a substantial expenses for the child, Lordship.
What's
There is
the
a
expenses?
one maid servant is there.
Huh?
One maid servant is there.
Correct.
One school for the school purpose.
Correct.
And other and one tuition. One tuition.
So yeah, what is the total claim? What is the main claim?
Main claim, I have to check it.
What is the main claim?
Yes, I have annexed the application under 144. Lordship will get it from, my lord, page number P2, page 17. 90,000 per month.
90,000. That will be adjudicated at the final stage, Lordship. But so far the current income
90,000 for child.
No, not for child. That will be the final.
That's right. 90,000 for the child and the
Certainly
main
not.
prayer.
It can't be. I also know that it is absolutely exorbitant claim. I know. I do admit. But so far the interim maintenance quantum is concerned, so far the current expenses is concerned, it is absolutely compatible and equitable.
You do one thing, when the order was
Passed on.
My lord, order has been passed on 20th December 2025.
Yes.
You are not paid any amount.
Yes,
Yes,
my
yes,
lord,
making
up
payment.
to date,
Up to date.
up to date, my
Yes,
lord, with the
yes.
area maintenance.
So
there is no area.
Ah.
No, so since he has been making payment, so all the payments, so how the question of one challenging of the entire process.
The petition
Quantum.
has filed the present
My lord, I
division
am only
application
praying
challenging
for
the
the
interim order
proportionately, my lord, it
interim
will be
maintenance order
distributed.
passed by the London Judicial Magistrate First Court Alipur Dwar, wherein the London magistrate has directed the petitioner to pay rupees 30,000 to the mother being the maintenance of the minor as interim maintenance. Counsel for the petitioner submit that the petitioner is a doctor by profession and he is getting the salary of rupees 95,000 per month. If she further submit that the wife of the petitioner is also working as a doctor in the government college and a government hospital and is getting the salary of rupees 90,000, which she has declared in the affidavit of assets. She further submit that the London magistrate only taking into consideration of the income tax return that the petitioners has declared the annual value of rupees 13,79,573 has as an order for grant of interim maintenance to the child of rupees 30,000 per month. Full stop. The London Council for the petitioner submit that the son is only 7 years old and he is studying in class 2, and as such the 30,000 the order passed by the London magistrate for grant of interim maintenance of rupees 30,000 is highly excessive and without any justification. Full stop. Per contra, London advocate appearing for the husband wife respondent
Son.
to the son submit that the London magistrate has taking into consideration of the expenses and the education expenses and the other expenses of the minor, and also taking into consideration of the annual income of the husband, has passed the order of interim maintenance of rupees 30,000. He further submit that the husband is already paying the 30,000 since the date of order, and he has complied with the order, and as such the revisional application is not maintainable. Fully London Council for the petitioner and the husband, the minor, further submit that that 30,000 per month is required for his education and other miscellaneous expenses. expenses, and thus the London magistrate has rightly passed an order by directing the petitioner to payment of rupees 30,000 as interim maintenance. Had the London Council for the respective parties peruse the materials on record. The London magistrate, the wife has filed the application section 144 of the BNSS for grant of maintenance to the minors. The main claim of the wife for maintenance of the minors is rupees 90,000 per month. The London magistrate in the interim maintenance, the wife has paid for what is the amount you have paid in the interim maintenance?
90,000. 90,000.
1/3
has paid for 90,000 per month, being the interim maintenance also. The wife has submitted her affidavit of asset declaration, wherein she has stated that her monthly income is 90,000 per month. In this declaration, the wife has also stated that there is no liability. There is no liability upon the wife. The London magistrate, while passing an order for directing the directing the petitioner for payment of rupees 30,000 being the interim maintenance to the minor son, has only considered the income tax return, wherein it is mentioned that the annual income is 13,79,573. The London magistrate failed to appreciate that both, that is the wife and husband, both are the doctors. Accordingly, the annual income, naturally the annual income would be rupees 13,79,573. The London magistrate failed to appreciate that the age of the son is 7 years and he is the student of class 2. He also failed to appreciate that the mother is also working woman and getting working as a doctor in the government hospital and getting a rupees 90,000. Considering the above, this court find that the London magistrate has considering the above, this court find that the London magistrate find that by the London magistrate failed to considering the above, this court find that the granting interim maintenance of rupees 30,000 to the minor son who is only 7 years of age, and the wife is also a working woman of getting rupees 90,000 per month, and the husband is also a doctor who is getting rupees 95,000 per month. Thus, the granting interim maintenance of rupees 30,000 to the minor son is not justifiable. Accordingly, the order dated, what is order?
My lord, order dated 20th
20/12/2025 granting maintenance, interim maintenance of rupees 30,000 is modified to the rupees 20,000 per month. 20,000 per month. This order will not prevent the London magistrate to decide the maintenance application on merit.
One more, it will be applicable for prospective effect.
Yes, naturally.
I'm grateful.
In regard, cousin, whatever the amount paid by the petitioner that cannot be adjusted as the areas, henceforth the petitioner will pay rupees 20,000 per month.
This is applicable from date of.
Whatever the amount paid by the petitioner in terms of the imputing order, the amount shall not be adjusted. Henceforth, the petitioner shall pay rupees 20,000, being the interim maintenance to the minor son. Until the next 40.
My lord, I am for the petitioner, my lord. My lord, the present revisional application is for my lord to direct for expeditious trial, my lord, direction upon the learned trial court, my lord, for complete the trial, my lord, within a time-bound manner, my lord. My lord, the FIR was registered on year 2010, my lord.
What is the case?
7th of June, my lord.
What is the section?
My lord, I served as the government employee, my lord.
What is the section?
My lord, section 409 of IPC, my lord.
Correct.
My lord,
How many accused persons?
My lord, there are 2 accused persons, my lord.
2 accused persons.
My lord. My lord, as per your lordship's direction, my lord, My lord, order 60, by the order 60, my lord, there was a previous direction of Honorable High Court, my lord, to conclude the trial expeditiously. However, my lord, I have communicated the same with my lord, the petitioner, my lord. My lord, he has not preferred any previous application for expeditious trial, my lord. That may be, my lord, the another accused petitioner, my lord. I am not aware of that.
Now, how many accused persons are
My
there?
lord, two accused persons are there, my lord.
Two accused persons are
Yes,
there.
my lord.
So already there is an order from this court.
However, my lord, there is no progress in the trial, my lord.
What can be done?
My lord, kindly, my lord, he serves, my lord, as the ex-serviceman, my lord, and
What is the
senior
stage of the,
citizen.
what is the stage of the trial?
My lord,
How many witnesses?
out of
many witnesses in the charge sheet?
my lord, 19 witnesses, my lord.
19. How
Yes,
many
my lord.
witnesses have been examined?
My lord, only 8 witnesses have been examined, my lord, till date. My lord, this lackadaisical, my lord, process.
After 15 September 2025, there is no order.
That is the last order, my lord. Order number 60. Order number 61, my lord. 3/2 of 2026.
For
My lord.
appearance of the accused and report, both the accused court and below present by filing order. No report. Not report. What report?
My lord, due to my lord pendency of this present proceeding, my lord, his provisional pension is also stopped, my lord.
No report. What is report?
My lord, that may be in compliance report of
What
the
report?
district magistrate, my lord.
What?
Regarding, my lord, the investigation.
What investigation? After charge sheet?
Office report. My lord, office report, my lord.
What report? On scrutiny of the evidence.
My lord, that is order 60, my lord.
But how this court can direct the trial court for expeditious hearing? So many.
My lord,
matters
very
are-
old case, my lord. In
Maybe.
2011, my lord, charge sheet has been submitted.
Kindly see the FIR registered on the basis of the inquiry report of the DM.
District magistrate, my lord.
Correct.
Yes,
And
ma'am.
subsequently, there are 2-3 memos. At
Yes,
the
ma'am.
time of evidence of the BW1, that inquiry report was not available. Now the court has directed the DM to produce that inquiry report.
My lord, that too
What
taking.
type of the investigation? What type of the trial is going on before the trial court?
My lord, that is
When
very
the trial court is conducting the investigation. Is there any application filed by the prosecution under 91?
No, my lord.
So how this?
That, my lord, I have to take instruction. My lord, kindly, my lord, one day accommodation may be given.
What?
My lord, I will take proper instructions, my lord.
The petitioner has filed the present revision application only with the prayer for direction upon the learned trial court for expedite the trial of the trial special case number 5 of 2011 pending before the learned court of special judge special court EC Act.
My lord, kindly Monday fix on Monday.
Huh?
Kindly fix them around Monday, my lord.
Why? Judge special court.
I'll take, my lord, all the documents, my lord,
pending
necessary.
before the judge special court has come ASJ second court Sadar Kuch Bihar. Counsel for the petitioner submit that the case has been initiated against the petitioner in the year 2010. After investigation, after completion of the investigation, charge sheet has been filed. All in the charge sheet altogether, 19 witnesses have been cited.
Yes,
Out of the 19 witnesses,
only 8 witnesses have been examined, my lord.
8 witnesses have been examined. And due to the pendency of the present case, the petitioner is not getting his service benefit.
Provisional pension, my lord.
Service benefit, including the provisional
Pension.
provisional pension. And under such, he prays for a direction upon the learned trial court for expeditious disposal of the trial of special case number 5 of 2011. At the land counsel for the petitioner perused the matters on record. Admittedly, the case is of 2010 and 2010, and the case is at the stage of evidence. Accordingly, the learned trial court, learned trial judge is requested to complete the trial as early as possible, preferably within a period of 1 year from the date of receipt of this order. CR so disposed of. Yes,
Yes, my lord.
1 year.
My lord. Lord, he's a senior citizen, my lord, and
What can be done?
suffering from several neurological
See,
disorders.
document, if the document is there, that could have been disposed
But
of.
disposed,
8 month kari then.
Yes.
41, please, my lord. Well, 41, 42 are connected.
Yes.
For the first time, I see your lordship with a relatively lighter board, my lord. Really happy to see your lordship, my lord. What do you do at the principal bank? And my lord, I can assure your lordship, my lord, I'm not going to add the burden. It's in fact a story, my lord, Alice in Wonderland. Before your lordship opens the brief, my lord, both are same, my lord, one proceeding, different accused person. So 41 may decide the fate of 42. My lord, it's the one person, my lord, called my lord Ram Avatar. He purchased a property in 1964. In 2012, he, according to him, for the first time got to know at his property, there's a petrol pump running. He filed a civil suit, my lord, seeking recovery of possession. That the defendant filed a written statement, my lord, in 2016 saying that, look, this property we have purchased from X. X had purchased this from Y. Y had purchased it from U. So therefore, this is the chain that was disclosed in the written statement. But that happened in 2016. In 2017, the petitioner, this Ram Avatar filed an application seeking implement of the sons of that gentleman who was the defendant. Now, subsequently, my lord, he filed an application seeking amendment of the plan that was allowed. There is a revision file that's pending before this honorable court. Now, in the meantime, what that Ram Avatar did, my lord, the Ram Avatar filed a complaint, lodged an FIR directly.
Who's the plaintiff?
I'm sorry, my lord.
Who is the plaintiff?
Who is the plaintiff? Your lordship is right, my lord. Ram Avatar lodged an FIR against the sons of the defendant and other persons, saying that, look, I had never sold the property to one Onimes. Therefore, from Onimes to X, X to Y, Y to Z, and to these persons, this chain is incorrect. But there is an investigation. The investigating agency, my lord, interestingly filed a charge sheet which is impugned before your lordship, thereby making, my lord, the sons accused, who are the petitioners in the first case, prior to them, who are the owners, my lord, also made them parties, my lord. They are the petitioners in the second case. Now, who was prior to them, my lord, who was the party, one Dilip. My lord, it was from my lord, plaintiff to, my lord, Onimes to Dilip, then Dilip to this person.
You are the fourth person.
I'm obliged, my lord. Now, Onimes goes out of the window, he was exonerated. Dilip is not an accused.
Not?
Not an accused even. Now, my lord,
You are the third person.
I am the fourth person. Third person is the petitioners in third person. Sorry, my lord, I am the fifth person. The petitioners in 41 are the fifth persons, and petitioners in item 42 are the fourth. Now, my lord, the grounds I have: A, if Onimes is not an accused, my lord, I cannot be an accused. A. On top of that, my lord, the second fundamental ground I have, if your lordship sees the charge sheet, in a charge sheet, there's no whisper about any forgery. And the main fulcrum what I have, according to the de facto plaintiff, the forgery had occasion in a deed of 1985. The deed of 1985, I just show just give the original. Original, my lord. Admittedly, neither of the petitioners of these two petitions, my lord, they were parties to this, my lord. It's only Onimes was the party, the purchaser. Kalis is the original, my lord. Just give me a touch. Well, see, who was the purchaser, my lord? Ram Avatar was the seller, my lord, subject to correction by your lordship. And Onimesh Mukherjee was the purchaser.
Yes. So this
1985 deed.
1985.
When the first petitioner, my lord, was 15-year-old, the second petitioner was 10-year-old. So we are not into the picture. So therefore, my lord, we cannot be entangled at all. And my lord, the best point is, which I have left out, just to place at the end, my lord. In the charge sheet, there is no whisper about any forensic examination of the deed regarding the genuineness of the signature of the vendor. Now, my lord, the plaintiff disputes his signature in the deed of 1985, wherein we are not parties. First of all, in order to establish the forgery, my lord, the signature has to be belied, my lord. So there was no forensic examination of that with deepest respect, my lord. So how can there be forgery? No, there is one more addition to this, my lord. Your lordship knows, my lord. There is a judgment of Justice Honorable Supreme Court, my lord. This is called, my lord, Muhammad Ibrahim. There is a, my lord, profound paragraph in this, but it was by Justice Ravindran, as his lordship then was. But the principle, before I take your lordship to this, my lord, Muhammad Ibrahim says that if, my lord, so his case is, my lord, that his property was sold out behind his back when there is no evidence in this. Now, so far, I am not for the onimus. Onimus is discharged. I will, my lord, show that portion. So far, we are concerned, my lord, the fourth purchasers and the fifth purchasers, my lord. So far, we are concerned, the property, fourth purchaser had purchased and sold out. The fourth purchaser did not have any title because who had sold him, he did not have any title. And equally, my lord, we are in the possession. We are the persons, fifth purchasers. So the property, what we have purchased, my lord, no title have been transferred to us because there is no title at all. Now, if that has happened, the Honorable Supreme Court says, my lord, kindly see para 23, that if anybody is cheated, then the purchaser is cheated, my lord, not the seller, because there will be no passing of any title. My lord, there is a clarification. The paragraph starts at clarification, my lord. Para 23. My lord has got it, my lord. Yes. I'm obliged. My lord, if I may say so, when we say that the execution of a sale deed by a person purporting to convey a property which is not his, as his property is not making a false document and therefore not forgery, we should not be understood as holding that such an act can never be a criminal offense. If a person sells a property knowing that it does not belong to him and thereby defrauds the person who purchased the property, the person defrauded, that is, the purchaser may complain that the vendor committed the fraudulent act of cheating, but a third party who is not the purchaser under the deed may not be able to make such a complaint. So, my lord, if anybody is victim, my lord, the petitioners before the LOC, they are the victims because there is no transfer or passing of any title to them. So we cannot be in the dragnet, my lord. My lord, now I show the charge sheet once, my lord. My lord, kindly, my lord, it is as a certified copy, which your lordship will have, my lord, after page 112. But this is certified copy, which is it's not marked, my lord. After page 113, your lordship will have some loose, my lord, some applications. Then, my lord, charge sheet final report, my lord. My lord has got it.
Yes,
I'm obliged, my lord. My lord, the charge sheet starts. Your lordship will see the first page. Then the second page, my lord, there is a paragraph called, my lord, result of laboratory analysis. There is nothing. Then, my lord, para 17, brief facts of the case. But it's the second page of that charge sheet. Well, if I may place, my lord, on 27/6/2018, on Ram Avatar of such and such lodged a written complaint to the effect that he acquired a land measuring such and such by way of purchase under a registered sale deed bearing number. Then you also will see the date 4/7/1964 from erstwhile recorded owner, namely Nasiruddin Mohammed. Lastly, on 10/4/2011, he found that one Kishan Agarwal, the father of the petitioners of the first petition, is operating his business on the said land. Finding no alternative, the complainant filed a suit before the learned civil judge, Junior Division Jalpaiguri, against Kishan Lal, who in appearing in the said suit challenged the complaint. Sorry, my lord, complainant have transferred the said landed property to one Honorable Mr. Mukherjee under a registered deed. My lord, the deed I have handed over, my lord, 3568, and subsequently Nirmal Kumar Agarwal and Pradeep Kumar Agarwal acquired the said land. Said Kishan Kumar also supplied Xerox copies of the deed number such and such, on perusal of which the complainant found that the signature of the deed is not his signature and the same has been forged with intent to cheat and grab his landed property. Subsequently, being endorsed, such and such took up the investigation of the case, and on account of his transfer from the PS, it was endorsed to me. I accordingly investigated. Then Mala says, considering the facts and collected evidence, a prima facie case under 420, 468, 470, and 120B of IPC is well established against, my lord. Your lordship will see the names. It will not be relevant now, my lord. Kindly comes to the next page because your lordship will get the name in a better way, my lord. Next page. In course of investigation, allegation against Kishan Kumar Agarwal of such and such, the father of the petitioner could not be sustained, and the identity of the accused persons of such and such could not be established at this stage of investigation. After due consultation with such and such, I am filing charge sheet. Then, my lord, says paragraph 12 continuation. Particular, there is a box given. Particulars of accused persons charge sheeted. My lord, Nirmal and Pradeep, the two brothers who are the first petitioners in the first petition. Then, my lord, 3 and 4, husband and wife, my lord, who are the fourth purchasers and petitioners in the second petition. Then, my lord, one Swarno Kumar Banerjee, not before your lordship, and his wife. Then sees, my lord, para 13 continuation, a particular of the accused persons not charge sheeted. Kishan Kumar Agarwal, Animesh Agarwal, and Dilip Kumar Das. Now, my lord, this is worse than, my lord, Alice in Wonderland. The main person, my lord, who is at the epicenter, he was treated as an apostle, my lord, and when we are, my lord, millions of, my lord, miles away from that, we are being attempted to be crucified. When in law, my lord, we cannot be. Because if anybody has lost something, my lord, anybody has suffered the loss, we have suffered the loss. Because title has not come to us, my lord.
Considering the facts collected evidence, Nirmal Kumar Agarwal.
Nirmal is the first petitioner, my lord.
Yes.
Nirmal and Pradeep, the petitioner number 1 and 2 in the first petition.
Correct.
Then, my lord, Ravindra Pal Singh Chaudhuri and, my lord, Srimati Sukhdev Chaudhuri are the petitioners in the second matter.
Correct.
So they are the intermediary, my lord, purchasers. So with defense restaurant, there cannot be any case against them.
As per the complaint of authors, now the written complaint.
But see the written complaint, just prior to that.
Yes.
I kindly comes to the written complaint. I kindly sees, this is just, it will be just, it's 2 or 3 pages prior to the charge sheet, the FIR. It's a very short FIR. It's certified copy, I'm sorry, it's not marked.
Yes, got it.
I'm obliged. But this is the written complaint. To the officer in charge, such and such, sir, my lord has got it.
Yes.
I'm obliged. Sir, I, Ramavatar Agarwal, such and such, lost this complaint that I acquired the land measuring number such and such of such and such Khotiyan of such and such under the purchase deed bearing number such and such of 1964 from erstwhile recorded owner, namely such and such Mohammed, upon payment of full consideration.
So, as per the complaint, the first transfer in the name of Kishan Kumar.
I'm obliged, my lord.
Correct.
And first, kindly comes to, my lord, the next page, my lord.
Now, the kindly come to the complaint,
my lord.
Paragraph 2.
Right, my lord. That lastly on such and such, I came down to Siliguri and visited the aforesaid. I found on Kishan Kumar Agarwal by making intrusion upon my land and illegally raised Paka. So he came to know that that Kishan Lal has done it. But then, my lord, is para 4 on, para 3, my lord.
Accused 4 appeared in the suit and of late challenging.
And still para 4, my lord. It's on image.
That I have not transferred an inch of land of my property anybody, much less a Animesh Mukherjee.
Accused number 1.
And upon perusal of the copy of the deed, I found that the signature is not my signature. So as per his case, as per the first, he was the owner.
Obliged.
There's no problem.
No doubt.
Correct. So
he is transferred to Animesh, my lord.
Now, 1964
was the original owner, Mohammed. No dispute about that.
Now dispute on 1964 to the in favor of the complaint Rama.
Absolutely, my lord.
Correct. Now, second in 2011, Siliguri visited and found.
2011, you got to know about 1985 deal.
Correct. So 2011, he came down to the Siliguri and visited the aforesaid land, and I found one Kishan Kumar Agarwal who was making intrusion in my land and most illegally raised Pakka building. And then I find no other alternative, file a suit.
Right, my lord.
The accused number 4, who is the accused number 4?
But he was the father of the first two petitioners. He got exonerated in the charge sheet.
Okay, accused number 4 filed a suit, appeared in the suit, of late, filed an application challenging the transfer of the property to the accused number 1. To the accused number 1 is Animesh.
Animesh. Your lordship is absolutely right.
So,
so Animesh is let out, my lord. How can Animesh be let? But if Animesh is let off, then nobody can be an accused. And if anybody has to be prosecuted, it's Animesh.
And you have purchased from Animesh?
No, but from Animesh to Dilip, from Dilip to the petitioner, my lord, that Ravindra Singh Pal and Sukhdev Singh Pal, and from them we have purchased. But in the FIR,
now the IO report.
My lord, that's the charge sheet, my lord.
No, second, this 179, see the top 179
page. Yes, my lord, the documents were sought for, my lord. Your lordship is right. And then ultimately considering everything, your lordship comes to the charge sheet, my lord. This charge sheet was filed. Now in the charge sheet, he relied on the that 1985 deed that was never sent for forensic examination. So even, my lord, there cannot be any case against Animesh.
In the charge sheet.
But these are interlocutory reports, my lord. Your lordship need not bother your lordship with these reports, my lord. Charge sheet, my lord, just now have placed just few pages thereafter, my lord.
Charge sheet, where with regard to the deed?
My lord, your lordship will have that. 11 in charge sheet, first page, paragraph 11, under paragraph 11, the description of the property. Your lordship will see that 1985 deed, the original he obtained.
Number of acquisition.
My lord has got it, my lord. Description of the property, my lord.
Yes, yes.
My lord sees the first part is the certified copy of 85 deed. And then second part is the original book of volume such and such, stating deed number such and such, and the last deed of such and such. Then sees that 6/12 to 1985. And the certified copy I have handed over to your lordship. Now, admittedly, in 1985 deed, neither of the petitioners was a party. Now, my lord, if I now connect all the dots, according to the law of the land, my lord, Justice Ravindran's husband, my lord, which is absolutely locus classicus, that if anybody is victim, then these accused persons who are the petitioners, they are the victim barring Animesh. B, even Animesh cannot be prosecuted because the forgery in the deed has not been established against Animesh, which is why, my lord, he was let off. C, my lord, if Animesh is let off, then nobody can come in, my lord, because the chain is broken. That moment, my lord, the umbilical cord is snapped, my lord, then we cannot be brought within the dragnet. So therefore, my lord, there cannot be any offense against us, my lord.
Okay.
We are, but I'm praying for the fresh matter, in these to notice and stay of proceedings.
So you're pray for quashing of this?
Quashing of this, quashing of the proceeding. Your lordship is absolutely right.
The petitioner has filed the present application under section 482 of the Code of Criminal Procedure. 482 of the Code of Criminal Procedure, 1973, corresponding to section 528 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for quashing of the proceeding of NJP Police Station case number 460 of 2018, dated 27th June 2018, under section 420/468/471/120B of the Indian Penal Code 1860, pending before the learned Court of Chief Judicial Magistrate Jalpaiguri, being GR case number 2468 of 2018. Counsel for the petitioner submit that on the basis of the written complaint of one Sri Ram Avatar Agrawal, the police of PS NJP PS has registered the above case on the allegation that the complainant has not transferred any part of the land, any part of his recorded land to Animesh Mukherjee. But upon perusal of the copy of the deeds being number 3568 of 1985, the complainant found that the signature of the seller appearing in the said deed is not of the complainant and is being forged with the intent to cheat and grab the property of the complainant. Full stop. On the basis of the said complaint, and the police stop. On completion of the investigation, police has submitted charge sheet. In the charge sheet, the investigating agencies have relied upon the certified copy of the deed being number 3568 of 1985 and the original and the deed number 3499 dated 25/11/1985. It is the specific case of the complainant that the Animesh Mukherjee has committed forged upon the complainant by transferring his recorded land in his favor by way of registered deed, though the signature appearing in this registered is not is of the complainant. But while filing the charge sheet, the investigating agency has left Animesh Mukherjee free from the said case, but has entangled the petitioners in the present case for the alleged offense under section 468, 420, 468, 471, 120B of the IPC. Learned counsel appearing for the petitioner submits that if it is the specific case of the complainant that the Animesh has committed forgery upon the complainant and had got the land transferred by way of registered deed, but the signature appearing in the registered deed is not of the de facto complainant, but the police has submitted charge sheet by letting the Animesh Mukherjee free and entangle the petitioners in the present case, the prosecution will not be able to prove the case against the petitioners. In support of his submission, the counsel for the petitioner has relied upon the judgment in the case of Muhammad Ibrahim and others versus State of Bihar and another, reported in 2009, volume 8, SCC 751, wherein the Honorable Supreme Court has held that the execution of sale deed by a person, purporting to convey a property which is not his, and his property, is not making a false document and therefore not forgery. Full stop. In the full stop, by referring the said case, learned counsel for the petitioner submit that in the present case, if the police has come to the conclusion by filing the charge sheet that the Animesh, there is no case made out against the Animesh, thus there is no case cannot be made out against the petitioner's hearing. Considering the submission made by the counsel for the petitioner, peruse the materials on record and the judgment relied by the petitioner, this court find that the petitioner has made out an arguable case which is to be decided only giving an opportunity of hearing to the petitioner, to the state as well as
To the opposite party number.
to the opposite parties, as state as well as the opposite party number 2. Petition is directed to serve the copy of this application along with the documents to the opposite parties within parties and to file affidavit of service on a returnable date. Pending disposal of the revisional application, the proceeding pending before the learned court of Chief Judicial Magistrate at Jalpaiguri, being GR case number 2468 of 2018, is stayed until further order.
Most of the same order may be passed.
Same order also. The same.
Absolutely. But the other two petitioners, same. Most obliged. But may I take your lordship?
Yes.
44.
43.
Oh, 41.
41, huh? 41, 42.
43.
There will be 43.
No, 43.
Madam. 43.
43, 43. 43.
Madam, I am appearing for petitioner, my lord. Madam, my lord, we are seeking quashing of the charge sheet. My lord, it is unique case your lordship will be finding in most of the cases. Wife used to file case against the husband and in-laws for torturing. Here your lordship will be finding that from the side of husband, when husband has died, the family members have filed FIR against the wife as well as the entire family member of the wife to prevent them from seeking further matrimonial relief against them. Your lordship, the unique FIR, your lordship will be finding it page number 19. If your lordship kindly come to page 91. I've also given the vernacular English statement there. Your lordship, page 19 is the FIR in Bangla vernacular, and translated copy I have given to page number 21. If your lordship kindly come to page 21 once.
Yes.
Now, my lord, you will be finding I, Suman Paulit, son of late such and such, would like to inform you that my lord, this is important. My brother, namely Suman Paulit, my lord, he is the victim. Aged about 23 years, married one Priya Parmanik Puja, daughter of Kanai Parmanik. Before your lordship, Kanai Parmanik is the petitioner, and other person is Tapusa. Of such and such, were in love affairs. Their marriage completed 1.5 years back. Then after their marriage, his wife started physical and mental torture upon my brother and creating pressure for bearing the household expenses of his wife's parental family. Family members of both sides agreed to give their social marriage on 20th February 2025. Now, this is very relevant. After the marriage, my brother used to stay with his wife in their. This is most important. After the marriage, my brother used to stay with his wife in their new residence address. They are admitting that the wife and the deceased person was residing separately at the new address after the marriage. Now again, thereafter the family members of the both side agreed to give their social marriage on 20th February 2025. So my lord, there was a marriage. They were residing separately. No persons were with them. Now both family members agreed to give their social marriage on 20th February 2025. Now again, and due to his reason, the wife has started to pressure upon my brother for money. Hereafter, they have created a story. My brother was a vegetable seller by occupation. My brother accumulated some money amounting to 50,000 for his marriage ceremony from our grandfather, namely such and such. Of such and such, after came to knowledge of his wife regarding the money of amounting such and such, wife demanded the entire amount of 50,000 for the purpose of marriage shopping. My brother then offered rupees 10,000. Then his wife started quarreling with my brother, and thereafter started assaulting my brother. But even if you presume that there is an allegation, then these allegations are cornered to the wife only. Priya Parmanik intimated the entire matter to her family members, and after some time at about 10 p.m. in the night, my brother informed our mother, namely Lakshmi Palit, through cell phone that the in-laws, namely Priya Parmanik, Kanai Parmanik, Mamta Parmanik, Tapos Saha, Gopal Saha, before your lordships are Kanai Parmanik and Tapos Saha, Gopal Saha, are conspiring to kill him. Now, my lord, only on the basis of this one line statement, my lord, the entire family members of the wife were haunted. Now, the real fact is that if your lordship kindly come to my application, paragraph, lordship kindly come to my application.
Now, what is the section?
Sections first, my lord, they were charged entire family members for abatement of suicide. Later, they submitted charge sheet under section 103, that is for murder. Now, my lord, under these circumstances,
murder?
Yes, but astonishing. The report of PM is very clear that death was due to drowning and injury. He has jumped in the river, he died, perhaps there was injury. Now, referring to that injury, only on the basis of that injury, my lord, the entire family members, and your lordship was finding from the FIR that there was not a single line allegation against this particular person beside saying that they were conspiring. So, my lord, if there was an allegation of conspiring, then it was the duty of the officer, investigating officer, to investigate the part of the conspiracy. Now, my lord, on the part of conspiracy, the entire family member will be pushed to suffer the criminal trial under section 300 to 103 of BNSS. Now, this is very, very clear, my lord. They want to suppress the claim of the wife because they are admitting the marriage of the wife in the FIR itself. Now, when wife intend to go there, reside there,
since they don't want this particular lady in their house, and since these persons were supporting the claim of the wife, the entire family members have been brought in the case like this. And they have charge sheeted. Rather, she should file DV Act 125 498. She did not file. To prevent her claim, this type of unique FIR has been filed. Just kindly see the admitted fact which I have referred in my application at paragraph 7. These were the facts which were admitted in the written complaint. Just I am reading if your lordship so permit me. Your lordship is on paragraph 7. Petitioner submit that the present proceeding has been initiated at the behest of the respondent number 2, prevent the daughter of the petitioner number 1 to assert her matrimonial right against them. In short, petitioner submit that the following fact was suppressed in the complaint. First, admittedly, the daughter of the petitioner number 1, Priya Parmanik, was in relation with Rishi Shivam Palit. I have read the FIR for your lordship. Second, admittedly, the Priya Parmanik and Shivam Palit married as per Hindu rights and custom. This is there in their FIR also. Admittedly, the family members of both sides were aware about the marriage, and Priya Parmanik and Shivam Palit was residing together as husband and wife. They have also admitted that they were residing separately. Now again, my lord, admittedly, both sides of family members decided to their social marriage on 20th February 2025. Now it is the family member of Shivam Palit, the victim, who was not happy with the marriage. They forced him to reside separately. That is why he has committed suicide. Rather, it is the wife who went to the police station to file FIR against him. His missing FIR that was suppressed, and later when dead body was found, the entire family members of the girl side was implicated in this case. Now, if these things are going on, this lady.
So whether you persons have been arrested?
My lord, the wife was arrested, mother-in-law was arrested, they got bail. Now, my lord, we are seeking stay of the entire proceeding. Charge has been submitted on such weak piece of evidence. My lord, what are the evidence for which they will be sending me for trial? And trial like murder, only on the basis of the statement that they were.
So you file an application under 227 before the trial court.
No,
why caution?
I
filed the application before the trial court for discharge. There is no case is made out.
No, those copy has not been supplied to us. 207 papers. And my problem is that my anticipatory my anticipatory bail is rejected. I cannot come to the trial court by seeking discharge.
So that's why I'm asking whether you have been arrested or not.
No, I
have been arrested.
No, I have not arrested. My anticipatory bail is rejected. The moment charge sheet is filed, we are filing this quashing application saying this that the charge sheet.
So still you have not been arrested. You have not been surrendered before the court.
No, my lord.
So how? So you can directly, you could not get the directly, you're coming with the indirectly by filing a 482 application.
Well, there is
Either
no
you go surrender and file an application before the trial court for your discharge.
For these type of cases, my lord, the persons will go behind the bar.
Correct. But the problem is that, sir, your anticipatory bail application was rejected. I don't know why the police been arrested. Then you have not.
Police know the fact what had happened. That is why police is perhaps not arresting me.
Correct. So not arrested you. So they have filed the charge sheet. They filed the charge sheet. What has been shown? Absconding.
I have legal remedy.
What has been shown? Absconding or what?
Absconding they will show, and my anticipatory will not.
Yeah, they are showing absconding. So you go and surrender. You go and surrender.
Surrender means I will be taken into custody, my lord. Under this weak piece of evidence, charge sheet has been filed.
No,
they should support their charge.
Priya was arrested. Priya was arrested.
Priya was got bail.
Priya got, but then you go and arrest. Because sorry, you want the proceeding be stayed and you not get the bail. Sorry, sir.
No, that is not the case. I am seeking quashing of the charge sheet because there is
correct. You filed the anticipatory bail rejected. I don't know why the police has not been arrested. Then you are coming here for the quashing. Okay, quashing it is not, but I will admit issue notice, but I will.
May sorry. Of anticipatory bail doesn't come as a bar for filing quashing application. Lordship is well aware about that.
But you have to surrender. You have to surrender. You can file a quashing application. I only can say that it can be heard after hearing the parties. That's all. No proceeding, stay, nothing was there.
This pleading I have
proceeding cannot be.
A proclamation has been issued on that ground, my lord. When I have challenged the proclamation order.
So you go,
my lord, may I just.
So you go and surrender. Production of the accusation.
I will be taken into custody, my lord. Question of liberty is there, my lord.
So you file another application, no problem. But
Proclamation has been issued, my lord, despite the aware that I have taken
the
legal
petitioner
remedy.
has filed the present application under section 482 of the Code of Criminal under section filed an application under section 528 of the BNSS, praying for quashing of the proceeding initiated by New Jalpaiguri PS case number 148 of 2025 dated 10th of March 2025 under section 108. Now added section 10T of the BNS 2023 pending before the Learned Court of Chief Judicial Magistrate Jalpaiguri being GR case number. What is the GR case number?
The GR case number I have given, my lord, that will be
2005 of 2025. Full stop. The petition is directed to serve the notice upon the opposite parties. It is made clear that this court has not passed any order for staying of the proceeding. The London magistrate is free to take appropriate steps in accordance with
stay after service, my lord.
Yeah?
My liberty to pray
Yes.
for stay after service.
Let the matter appear before the next available service.
But if there is liberty to pray for stay after service,
No.
but kindly grant this because CD will be there.
No,
There
sir,
will be-
you are anticipated, rejected, you're not, why you let us.
There is no law, my lord,
be
that
served
when
upon you.
well is rejected, I cannot file revisional application seeking quashing, my lord.
Yes, call the other matter.
Deeply obliged, lord.
Pass over matter, item number 36.
36.
Yes.
In that matter, Lordship, interim maintenance was allowed. Yesterday, Lordship was pleased to head out the matter at length. That the learned magistrate below was pleased to pass an interim order.
Who is for the other side?
Is there, Lordship?
Yes. Yes, what you taken time?
Yes, ma'am.
Yes, what instruction you have taken?
They have finished. They have finished.
We have finished everything. It's just
Yeah, they have already argued.
1 lakh payment has been directed.
No, only the question is that he has passed the interim order. Okay, interim maintenance can be passed at any stage. But the London magistrate stated that there is no evidence. Evidence of the petitioner was already, and cross-examination was there.
Great.
So that finding is not correct.
We are pressing on that particular point only because after the evidence, Lordship, how can somebody give such kind of order in the application of interim maintenance?
And that too at the fag end of the trial. Initially, when the interim application was not filed, that ipso facto indicates that she is capable enough to maintain herself. Now, when the trial is on the fag end, they took out an application and got an interim order of 1 lakh. Any other now? For the petition. What are the 41, 42? For the petition, opposite party. Opposite party.
Now kindly come to the inner page 3 of the interim order.
It appears that the status of the petitioner being the legally married wife.
Now leave
of the
aside
opposite
the
party-
second.
Let me for my satisfaction. Is not in the dispute. It is also not disputed that the petitioner and the OP has been living apart. While the petitioner has alleged about neglect and refusal on the part of OP husband, the OP has contended that the petitioner has caused mental harassment and threat on the ground of demanding partition in business and family money. Their relationship reached to such a bitter situation that OP did not make any statement that he wants to resume his married life with petitioner. Admittedly, the OP belongs to a renowned family in Darjeeling, having tea business in the name and style of HON'BLE Indala, and he has admitted to look after his wife in his written objection, so he cannot eschew himself from the legal and social responsibility to maintain his wife according to his status. In view of respectively pleading of both parties to this instant case, I find that in the absence of complete evidence on record, it is next to impossible for the court to adjudicate upon the rival contention at this stage of the case. Prima facie, nothing has come on record to show that the petitioner is earning herself enough to maintain herself. Rather, it came on record that necessary things like groceries and accommodation have been provided by to her by the OP and his family members. That too at the instance of the court while granting bail. Now, admittedly, the interim maintenance has to be decided on the basis of hearings and the income and assets affidavit filed on behalf of the parties. A balance has to be drawn between relevant factors, as there is no straitjacket mechanism for fixing the quantum of maintenance, and inter alia includes the status of the parties and reasonable need of the wife. Besides, it is the settled law that the wife is also entitled to enjoy the same amenities of life as she would have been entitled in her matrimonial home. However, in absence of any prima facie evidence on record that the petitioner has sufficient source of her income of her own, which is sufficient to maintain herself, in my humble view, the petition for interim maintenance should be allowed, as the scope of arbitration at this stage is abridged. Having regard to the object of legislation, the information about the status of the parties as could be obtained from the pleadings affidavit filed by the petitioner and OP need of the petitioner for a modest living, the inflation trend of market, I find that an interim award of 35,000 per month for herself until further order would be reasonable. It's a justified order, Madam.
That's what I'm telling. You're not heard my, because kindly come to that. You heard the paragraph page 3, inner page 3, paragraph, second paragraph. Correct?
Yes.
Second paragraph, then it comes to the up to paragraph 4. Whether this observation is not contrary to the evidence led by the petitioner as PW1, page 28, 29 of the petition, because he is telling that there is no evidence. It is to be decided on affidavit, because interim application is to be decided on affidavit by taking into consideration of the affidavit
Has
assets.
not yet been submitted.
Yes,
Affidavit asset has not yet been submitted.
but
It has to
affidavit,
be.
but evidence is going on. Your cross-examination is completed. That has not been considered. In the affidavit, you kindly come to the page 29. Kindly come to the page 29. I have been advised by my doctor to go to the gym, yoga 8,000 rupees. And for gym, 3,000 rupees. Every month, 3,000 for the
Yes,
monthly
Malad.
water service.
This I'll show one thing, Malad. I'll tell you.
The only curse such
You have submitted, let me finish. Let me finish. We'll get your chance. But even if they are providing the sustenance, but it is not.
I am not providing. I am on the ground that, okay, interim maintenance can be passed at any point of time.
Yes.
There is no dispute.
Yes.
But the finding which the magistrate has come to the conclusion, there is no evidence. But your petitioners have been examined and cross-examined.
It has been recorded.
Where it is recorded? Kindly come to the, that's why I'm telling. Kindly come to the page 3.
Thereafter, Malad.
What thereafter? Kindly come to the page 3.
Malad,
The
kindly
second
comes to-
paragraph, read the
kindly
second
comes to
paragraph
page
again.
4, Malad. Having regard to the object of the legislation, the information about the status of the parties as it could be obtained from the pleadings, affidavits filed by the petitioner.
Yes, affidavit filed by the petitioner.
Yes.
Affidavit, what affidavit? With regard to the interim application.
Affidavit in chief.
Interim application. If affidavit in chief is taken into consideration, then the cross is to be taken into consideration. If the cross is to be taken into consideration, what is the amount?
Malad, if you also kindly comes to this third paragraph of the first page of the order. It is pertinent to mention here that this interim maintenance petition has been filed by the petitioner at the stage of evidence being laid down by the petitioner in the original application.
That's why
Yes.
I am then kindly come to the page 3, second paragraph.
Yes.
Read. I find that in the absence of the complete evidence on what complete, your cross is over. So what further evidence is required?
Complete evidence. Complete evidence on record.
You will adduce further evidence.
Yes.
Okay, then I am staying this order. You adduce the evidence within a week, then complete. You are not understanding. Complete evidence, what? The other person will come, yes, this amount
The
is
evidence
required to
of
the
the
wife.
husband, the evidence of the husband is left.
Complete evidence of what? Wife.
Complete evidence on record.
Yes, kindly see the complete evidence, the wife evidence is concluded.
Yes.
Kindly conclude, this, the amount, what amount you have claimed in the examination chief?
1 lakh.
Yes. So where is the calculation? Where is the calculation? See, the magistrate should act on the four corners of the evidence available on record. It is not he has a power to pass any interim order, the 35,000, 40,000, 60,000. It can be, but it has to be taken into consideration. Interim maintenance, we filed on the basis of, and you're telling that he is telling on the basis of the affidavit. Affidavit is the interim maintenance. He left the evidence led by the petitioner. And for the yoga, for the gym, all those things you wanted to live in the lavish life.
Yes. But for this, I was trying to show your lordship one judgment of this honorable court color. And if you lordship kindly see paragraph 10. Well, it's reported in 2024 SCC online, Calcutta 11952.
Yes.
Malad, page number 6. C. Where the wife is earning some income. The courts have held that if the wife is earning, it cannot operate as a bar from awarding.
That is not, that court is not telling here.
It has to, I have to leave at par. They cannot deny that.
Sir, again, you are not understanding. My only simple question is, my only simple question, please give the answer to the court. My only simple question is that once the party has adduced evidence,
that has
chief is conducted, cross has been done. Whether that is prevail over the affidavit or the affidavit will prevail over the evidence. So that is on my, since beginning I am telling to you.
Yes, that has not been taken into.
Then, and he has come to the finding there is no evidence.
For what finding?
The evidence of the petitioner is the main evidence. But other these the circumstances,
no.
He will bring the pay certificate, whatever it is, and it is the interim. Interim, what he has proved. Show me what is he has proved. Show me from the evidence what he has proved in the examination in chief.
And I'm start reading from paragraph page 27, last paragraph.
What CS proved? Show me.
Nagpur presently have 3 outlets. One at Leiden La Road, opposite to the State Bank of India, Darjeeling. One at Chaurasta, Darjeeling. And the third one opposite to Das Studio at Nehru Road, Chaurasta. Nagpurs have also have 5 godowns. One of such godown is below the Golden Height apartment. Prior to my marriage, to the opposite party number 1 was working as an air hostess at Jet Airways. Prior to my marriage, Shailesh told me to quit Jet Airways so that I, along with him, can take care of their business at Darjeeling. I had 2 miscarriages from this marriage. The first marriage I had was in the month of
that is your case. With regard to the amount, where is that? How you prove this? The paragraph, page 27, last paragraph, where is the proof? If you say, then I'll modify this order, pay 20,000 rupees. I am remanding back to expeditious disposal of the matrimonial, of the maintenance. That will be better.
See, instead of 20, she is proposing to fix it
50.
15.
50.
50.
If you are not ready 20, then I am giving the 50. Enhancing this. The petitioner has filed the present divisional application challenging the impugn order number 47 dated 8th of July 2025 passed in MR maintenance case number 2 of 2022 wherein the London magistrate has passed an order directing the petitioner to pay interim maintenance of rupees 35,000 per month for herself, for the wife, from the date of filing of the petition till the disposal of the case. Full stop. Full stop. Learned counsel for the petitioner submit that the London magistrate has passed the order only on the basis of the affidavit of the interim application. The counsel for the petitioner has brought to the notice of this case that the case is at the stage of evidence, and the wife has already been examined as PW1 and cross-examined in full. But the London magistrate, while considering the evidence of the PW1 only on the basis of the affidavit of the interim maintenance, has passed the impugned order. The London counsel for the petitioner further submit that the petitioner has already provided this, that ghee and all these things have been provided you.
Yes, yes.
Has already been provided, already supplied to his wife as per the demand, has already supplied 28 kg of ghee, 82 kg of edible oil, 27 kg, 276 kg of HON'BLE milk, etc. as per the demand of the wife.
Including the residence also.
As per the demand of the wife at the residence of the wife. Full stop. Full stop. He further submit that without considering the objection raised by the husband, the London magistrate has passed the order. London counsel for the respondent wife raise objection with regard to maintainability of the present application and submit that the petitioner has challenged the interim maintenance, order of interim maintenance in the revisional application without approaching the London Court of Sessions judge, where the first opportunity is available to the petitioner to file a revisional application before the London Sessions judge. Counsel for the petitioner has counsel for the respondent wife relied upon the unreported judgment in the case of Samrat Chaudhary versus Devjani Chaudhary, passed in CRR 3003 of 2025, dated 13th of February 2025, wherein the coordinate bench of this court has held that if concurrent jurisdiction is available, it is the matter of the propriety and judicial discipline that the petitioner must approach the first forum and invoke the jurisdiction of the High Court only in rare and special circumstances. Referring this judgment, the petitioner submit that the counsel for the respondent submit that the petitioner has not shown any special circumstances how the petitioner has filed the present revisional application without approaching the court of the London Sessions judge by preferring a revisional application. Counsel for the respondent wife further submit that the London magistrate, by taking into consideration of the affidavit and the materials on record and the expenditure of the wife, has passed an order directing the petitioner to pay rupees 35,000 an interim maintenance. Full stop. He submitted that there is no full stop. He further relied upon the judgment in the case of Neha Akhtar versus Safiqul Islam, reported in 2024 SCC online Calcutta 1194, wherein the coordinate bench of this court has held that even the wife is earning some income, it is the duty of the husband to maintain the wife. By referring this judgment, the counsel for the petitioner submit that the London magistrate has found that the petitioner being the husband of the respondent is not maintaining the wife, accordingly passed the interim order directing to pay the interim maintenance. Had the London counsel for the respective parties peruse the material from the court. As regard the question of maintainability raised by the London counsel for the respondent, this court finds that this court finds that by an order dated 31st of October 2025, this court has admitted the revisional application filed by the petitioner. After the admission of the revisional application, the respondent had appeared before this court on 18th of February 2026, 6th of March 2026, 20th March 2026 and 9th of April 2026. The respondent has not raised any objection with regard to the order passed by this court wherein this revisional application has been admitted. The petitioner has also not raised any objection with regard to the maintainability for the 4 dates when the respondent has appeared before this court and has taken time. Now, only at the time of final hearing of the application, the petitioner, the learned counsel for the respondent has raised objection with regard to the maintainability, and thus this court is of the view the maintainability of the revisional application has to be raised at the very first stage. But in the present case, the petitioner has not raised the respondent has not raised the maintainability at the very first stage and has appeared in the matter, has taken several times for filing affidavit in opposition, though the affidavit in opposition has not been filed. Accordingly, the question of maintainability is rejected. The point of maintainability raised by the respondent.
To this point, I have a case law which says that it can be raised at any point.
That is another maintainability. Full stop. London full stop. As regard the order passed by the London magistrate with regard to as regard the order passed by the London magistrate with regard to the grant of interim maintenance of rupees 35,000, this court find that the London magistrate has recorded the finding that in the absence of complete evidence on record, it is impossible for the court to adjudicate upon their rival contention at this stage of the case. Full stop. The London magistrate has decided the said interim maintenance grant of interim maintenance on the basis of the affidavit of the respondent wife in the interim maintenance account. The said finding of the London magistrate is incorrect and contrary to the record. As per the record, the wife has been examined as PW1 on 9th PW1 before the London magistrate, and cross-examination was also completed. Thus, the magistrate has the sufficient evidence before deciding the interim application. But the London magistrate, ignoring the evidence available on record, has recorded the finding that no evidence is available. In view of the above, the order passed by the London magistrate granting the interim maintenance of rupees 35,000 is modified by reducing the amount of rupees maintenance amount of rupees 35,000 to rupees 20,000 per month. 20,000 per month. The petition full stop by the above modification.
Warrant of arrest has been issued. Warrant of arrest has been issued. Also, it can.
Full stop. Have you paid the amount?
No, amount has been paid.
Not paid. Full stop. When you pay.
And the next
warrant of arrest may be.
No, we will not pay. Then warrant of arrest. You give an undertaking, then I will.
They have also given undertaking in the court bill also.
The petitioner is directed to pay the petitioner is directed to pay the interim maintenance at the rate of rupees 20,000 from the date of order till date, and to continue pay the interim maintenance till the disposal of the
date of filing.
Date of filing, yeah. Date of filing till क्या बोला? Filing of the interim application along with areas till date within a week from date. If the petitioner failed to pay, the magistrate, the London magistrate will take appropriate steps
So one,
for recovery.
one more direction. Main MR case number should be disposed of within a stipulated period of time. Main case, original case. Lordship, that is pending for unnecessarily.
Your DW.
No. That's why the
Your
timeline may be given. Lordship.
Sorry.
Grateful.
Yes. बोलो क्या है?
44.
Grateful, my lord.
44, 45 to 49.
44. Criminal division. Not today. Next. Yes.